Okay, we're on the record with the people of the state of Michigan versus Deshaun Malik Perry, case 2355480. Perry, defendant number 2, in charge with 1 count of jail, possession of weapon in jail. Count 2, police officer assaulting, resisting, and obstructing. Today is that for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Judge. Arnie Chambers on behalf of Mr. Perry, P63956. Judge, I have spoken with, visited with, and consulted with my client. I would waive his presence for the purposes of this hearing.
Okay, any discovery issues?
Yeah, I have paper discovery, Judge. I do not have the videos. I do believe that there would likely be a number of videos from the jail that I would ask to be turned over to myself for review.
Okay, Mr. Kirker.
I spoke with the OIC yesterday since the original video that was uploaded was the incorrect video. She'll be looking into it today and hopefully it'll be uploaded. As she explained, they don't show very much of the incidents, but she'll try to have them uploaded by today.
Okay, with that, Attorney Chambers, are you comfortable with setting an exam date?
Yeah, we can do that, Judge.
Okay, since he's in custody, I'm just trying to see if I can get him early. I have March 1st open.
I'm likely going to be in trial with Mr. Perry, Judge. Well, that's far more than likely. Mr. Perry has a trial set to start Monday.
I see.
And Frank Murphy.
How about the 2nd?
It's probably going to be a 4-day trial. We're looking at probably Monday through Thursday for this is what I'm expecting as of now, Judge. If we can go into the following week, that would be good.
Oh, yeah.
It's a 9:30. Actually, it's 10 o'clock.
Both of them there? Yeah.
How about 10 o'clock on the 6th?
Let's do 10 o'clock on the 6th, Judge.
Okay. All right, if you don't have discovery by Friday, the Friday before, just log on so that we can try to resolve it before the exam date.
Will do, Judge. Thank you.
All right, you have a good day.
Yep.
All right, Attorney Deshaun, good morning again.
Good morning.
Are you waiting for your client?
Judge, in all candor, he does not have a working cell phone, so I don't suspect he has access to the court. Whatever the court would prefer to do, I would prefer just to set a preliminary examination date. I have the paper discovery, just need the digital.
Okay, let's call it. Okay, we're on the record as the people of the state of Michigan versus Quincy Vassar. Case number 2355549. Mr. Vassar is defendant number 1 in charge with count 1, attempted home invasion. 3rd degree, habitual, no, that's not, no. Strike the habitual offender. Just 1 count of attempted home invasion, 3rd degree, set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. May it please the court, Kim Michon, Neighborhood Defender Services, P59167. It's my pleasure to represent Mr. Vassar. We would waive his appearance for these purposes if the court would permit.
I will. And you stated that you have paper discovery and need digital, correct?
That's correct, Your Honor.
Okay. Mr. Kirk.
I have my notes that I sent both paper and digital on the 17th to the main page. But if you don't have it, I could always resend it.
Yeah, I have no doubt it was probably sent. I'm simply indicating I don't have that digital, and since my reading of that discovery was the officers allegedly caught them in the act, that would be kind of good, important to have.
Mr. Kirby, you resend whatever. Okay. All right, Attorney Michon, I have March 1st, 2nd, 6th, 7th open.
I have matters in Third Circuit on both the 1st and the 2nd, and I start trial on the 6th. So if we could do early on either the 1st or 2nd, I would deeply appreciate that.
Oh, we can do 8:30, 8:45 on the 1st or 2nd.
Let's do 8:30 on the 1st.
Great. Okay, so December, March 1st, 8:30 a.m.
Thank you so very much, and I love you and your staff as always.
All right, 15. Okay, Mr. Burrell,
Yes.
Good morning, Your Honor. Attorney
Good
Barton.
morning. Are you ready on your client's case?
We are, Your Honor. Thank you.
Okay, this is the people of the state of Michigan versus Brandon Burrell, 2355480. Mr. Burrell is charged with count 1, possession of weapon in jail, count 2, police officer assaulting, resisting, and obstructing, causing injury. Today's federal cause conference appears.
Alexander Kirker on behalf of the people, P86282.
May it please this honorable court, Darnell Barton, P83363, on behalf of Mr. Brandon Burrell. Mr. Burrell, can you state your name for the record, please, only?
Yes, Brandon Dwayne Burrell.
Thank you. So, Your Honor, if I may, today's the time for probable cause conference. I have received paper discovery. Thank you, APA. There was a mix-up, I think, with the video discovery on that. We received an incorrect link, and they're going to resend a new one. So if that's possible, we would like to keep the examination date if possible and just go forward, assuming that they can get us that video as soon as possible.
Okay, Mr. Kirby, as this is a codefendant case, correct?
Yeah, there's 9 co-defendants in this case.
9? Oh, okay. That's probably why I can't find the file.
Understood. No pressure.
So, okay, we'll keep the date of March 6th at 10 a.m.
Oh, I'm sorry. I thought they had March 1st. Give me 1 second.
You said 9?
Okay. I had March 1st, but you have March 6th, Your Honor?
The co-defendant is, one of the co-defendants is Mr. Perry, I believe. I just said his for March 6th.
Oh, I got you. I'm sorry. I see what you're saying. Okay. Okay, we can move. If they're gonna do that date, we'll go ahead and do that as well. Just actually, you know what? I do apologize, Your Honor. I'm in Oakland County Circuit Court that morning at 10 a.m. I just realized that. Would I be able to zoom in, Your Honor?
For an exam?
I'm sorry. No, I'm mixing it up. I do apologize. I'm doing like 8 things at once. So yeah, no, we wouldn't be able to make that time for the exam on the 6th.
Okay. So I didn't realize it was that many co-defendants.
Mhm.
I don't see them all on track today. So if it hasn't been split up,
No, it's all on there,
They'll
Ronald.
be on the down.
they only turned it. This is all the first page.
The first and the second page.
Oh, I see number 9.
There's no 8.
Yeah. 18.
These are 2. And Holland.
5, 4, 3,
That one. He on that reference too. First page. Page in front of me. 2.
Your Honor, may I ask what time you hold your exams? Did you say 10 a.m.?
Next page.
So what happened is I scheduled Mr. Perry's exam for 10 o'clock on March 6th because I didn't realize he was one of 9 defendants. So I'm trying to figure out how we can schedule his exam.
Okay, if it'll please the court, I will try and figure out a way to maneuver the other docket. So just know that I'll try and work with the court.
Okay. So everyone may get an email for a different date if it's just not gonna work.
Okay,
So we'll set March 6th, 10 o'clock, but there'll probably be a large email being sent out from the clerk to all the attorneys to try to get a date.
all right. Thank you, Your Honor.
You're welcome. So it'll be March 6th at 10 a.m. for now.
All right, sounds good. I think we're all set other than that.
All right, have a good day.
All right, you all have a great day. Thank you, guys.
Any other attorneys on the 9 defendant case?
I am, Your Honor.
Good work.
This is Attorney Pilkowitz on Larry Coppins.
Coppins, okay. Let me call. I had no idea. I didn't know. Because I'm only seeing. This is. Mr. Kirker. So you're looking at the information. Do you see anywhere where it has all 9 defendants? Count 4. I see it. Count 4 has defendants 2 groups. So I have 10 there.
Yeah, I'm not sure where defendant number E is, the one that's missing. Oh, I thought it was one. No, it's that.
Yeah, okay, this is we're gonna have to go through this with more detail. It's a mess. Okay, let's start with deal with Coppins and then I'll have to go through this file and figure out. Okay, this is the people of the state of Michigan versus Larry Reginald Coppins, 2355480. Mr. Coppins is defendant number 5, in charge with 1 count of police officer assaulting and or resisting or obstructing. Today's the day set for a probable cause conference appearance.
Alexander Kirk on behalf of the people, E86, 282.
And Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Larry Coppins. I'd ask that the court waive his presence for purposes of this PCC. Mr. Coppins is in the custody of the Wayne County Jail.
Okay, I will waive his presence.
Thank you. Judge, just briefly, first, we're missing digital discovery, so I would request that at this time. We've only received paper.
Okay, and as the last 2 attorneys stated, they received the wrong link and Attorney Kirker will send the direct one.
Thank you. With regard to setting this matter for an exam, I represented Mr. Coppins on another case. He recently was pled guilty and was sentenced to a prison term on another far more serious matter. I anticipate that honestly, this matter could be resolved in the district court via dismissal or misdemeanor plea. With that, Judge, we would be asking for an adjourned PCC date, perhaps to set it 1 week out so I can speak with the prosecution about working this out.
Okay. So how about March 1st?
That's a good day, Judge.
Okay, and I don't know if you heard, so I scheduled the exam for March 6th at 10 o'clock. That day might not work for all the attorneys, but I think it's gonna be hard to get all 10 attorneys on the same day.
Understood, Your Honor. With regard to Mr. Coppins, I am actually out of state for the next couple of weeks. I won't be available to be in person for an exam until late March. All of that to say is I do not want to hold up the court schedule. I am, cautiously optimistic we can get this one resolved short of an exam. That being said, I would not be available on the 6th.
Okay, I'm just gonna set it and then hopefully on the 1st we have some good news for you.
Understood.
Okay, so I'll see you, let's do 8:45
On March 1st?
Yeah,
Perfect.
okay. All right, have a good day.
Thanks. I got one more, Judge. I got Wayland Huff.
Oh, okay. Can you print out, basically print out, John, you did mention 10, so I did. Okay, and then she said she got, I just need all of them printed out. Okay. So Mr. Huff first. And Mr. Huff has nothing to do with the other case. I was gonna-
Correct. I'm standing in for another attorney.
Oh, okay. All right, it's the people of the state of Michigan versus Wayland Dwayne Huff, 2260851. Mr. Huff is charged with 1 count of carrying a concealed weapon. This is a felony commission with a motor vehicle adult advisory that for a probable cause of today appearances.
Alexander Kirk on behalf of the people, P86282.
Neighborhood Defender Service by Jackie Pilkowitz, P81653, standing in for the attorney of record, Alexandra Choate. On behalf of Wayland Huff, I'd ask that the court waive his presence for purposes of this proceeding.
I will waive his presence. Any discovery issues?
No, Your Honor, we are in receipt of discovery. We are just setting this matter for an exam.
Okay, I have March 1st, 2nd, 6th, and 7th open. As early as dates.
We'll take the second.
Okay. I have, let's see the time. I have 10 o'clock open and 11 o'clock open.
Oh, actually, Judge, I apologize. I'm looking at my colleague's calendar. I'm so sorry. It looks like she might be in Romulus on that day. Just one moment.
Okay,
I'm so sorry.
that's fine.
What were the other dates you said besides the second, Judge?
The 6th or the 7th, or anything after the 6th or 7th.
Okay. Yep, the 6th is a good day, Judge. Thank you.
Okay, how about 9 o'clock?
Can we do 10? She's got to be over in Frank Murphy at 9. Oh, unless you're doing the co-defendant case. We can make it 9. She'll make it work.
Wait, you said
Or-
co-defendant?
If you're setting the, the other case with multiple co-defendants for the 6th, do you want to pick another day or do you want me to stick with the 6th?
If she can do 9 o'clock, other than that, we'll have to do another day.
Yeah, then let's do the 7th.
Okay, so how about 9:30 work?
9:30 on the 7th is perfect. All right, thank you, Your Honor.
You're welcome. Have a good day.
You too. Bye.
All right, let's see, Attorney Harris, good morning.
Good morning.
How are you?
I'm good, Judge. I don't think we've met before, but there's a 10 defendant case. I don't know how many, and I'm on number 10, Devon Sutton. And I don't know how we're gonna get an exam date, but I don't know how many of those 10 cases are up today.
All of.
Well, okay, I overheard on the other cases, the pre-set date was March 1st, which I was okay with, but March 6th, I got a jury trial across the street, at least as a present. So how we're gonna get 10 lawyers to agree on a date? But anyway, I'm on.
This is what I'm setting the date of March 6th at 10 a.m. But what I'm gonna do is have the clerk email all 10 attorneys and everyone agree on the date. So I'm just setting a date to put in the calendar to get past the PCC and any discovery issues. And then all 10 attorneys will have to figure out a date.
Okay, Judge, so do we have to put this on the record or can we just wait for the email?
We can wait for the email.
Okay, then, okay. If I may leave, I have a circuit judge that needs me right now to put a plea on the record. So, March 6th, and I'll let my client know that.
Okay, 10 o'clock, and that's just until you get the email.
Okay, well, I may have somebody standing in, or I'll get on Zoom or have somebody stand in for me if I'm in trial. Thank you, Judge.
You're welcome. Have a good day.
You too.
Okay. All right, let's see. Okay, Attorney Mortimer, you've been here for a minute. Good morning.
Good morning, Your Honor.
How are you?
I'm fine. How are you?
I'm trying to figure out this 10 defendant case right now.
Yeah, well, I'll make it easy. I represent Cortez Miller. He's one of the co-defendants. And I've already got it in for 10 a.m. on the 6th on my calendar. And I understand the court's going to send an email. No problem. I'll work to find a better date if necessary.
Wonderful. You did make it easy. Okay, do you want to go on the record or are you okay
I
with?
feel that I need to. I've spoken with Mr. Miller, who's currently in the county jail, and but he is expected to be released at the end of this week. He does have a personal bond on this case.
Okay. All right, so we're setting it at March 6, 10 a.m. Still the email sent out for all attorneys to agree on the date.
Thanks very much, Your Honor, and everyone enjoy the rest of the day and be careful with the ice.
Thank you, you too.
Bye-bye.
Thanks. Attorney Carmen, good morning.
Good morning, Your Honor.
How are you?
I'm here on Curtis Harris.
Just about Curtis Harris. You can be part of that. Harris is the attorney. Oh, you know. We're on the record list of people in the state of Michigan versus Curtis Harris, case number 2355549. Mr. Harris is defendant number 2 in charge with count 1 attempted home invasion, 3rd degree, with a habitual offender 4th offense notice set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P86-282.
Good morning, Your Honor. Michael A. Carmen, P73824, on behalf of the defendant.
And I just realized this is another co-defendant case. I called Vassar's case earlier and set a date for March 1st at 8:30 a.m. Does that date even work for you, Attorney Mark? I'm sorry, Carmen.
It does, March 1st at 8:30?
Yes.
Yes, Your Honor, that should be fine.
Okay. So I guess I should ask, do you have any discovery issues?
No discovery issues, just issues reaching my client. There was no phone number. I'm appointed. There was no phone number on the appointment sheet. And I have reason to believe because of the police report that he might be homeless. So I have not been able to speak to him.
I see. Okay. Do I have anything? Do you have his address? Well, you said he's homeless. I have an address listed. Do you have one?
I have on, it just says Margarita, 26539 Margarita.
I have it in Redford, Michigan.
Yeah, it doesn't even have a city. It just says Margarita.
So I have it as Redford, Michigan.
With that street?
Yes, yep.
Okay.
Maybe
I can try
that'll help.
sending him a letter there.
Okay.
But based on the police report, Your Honor, I have reason to believe he's probably homeless. Your Honor, for the first, do you think we could set that a little bit later in the morning?
Let's see. The other attorney, who was that? Who just said Vassar? Attorney Michon just said it for 8:30. I think she has something later on that morning. It'll be another email. I'll send out to you all to get the date for time.
I mean, 8:30, I can make it work. I might be a little bit late signing on if that's
That's fine.
okay.
That's no problem.
Okay, on the first then, I will see you then, Your Honor.
Okay, you have a good rest of your day.
You too, thank you.
Attorney Richards, good morning.
Good morning, Your Honor. I'm here with Miss O'Meara on Harvey Arnold that's up tomorrow, but we have an issue regarding his admittance.
Your audio broke up. All I heard was I have an issue.
Regarding he's supposed to report to the forensic center today for a bed, but he has to have his tether removed. And the jail says that we need a court order for that.
Okay. So you need me to sign a court order?
Right. We would need to ask the court to send an order to Dickerson facility, removing his tether.
Okay. Can you call the courtroom? And we can. No, she did say Harvey Mitchell. Yeah. Okay, can you call 965-406 and talk to the clerk and we can figure that out?
Yes, 96540.
2406.
Oh, okay, thank you.
I'm
All
also
right.
on my case, Your Honor. That's why I'm here. Ms. Richards and I both have cases with Mr. Arnold, so.
Okay. Yeah, the clerk will figure it out and we'll send an order over.
Thank
Okay.
you.
Alasa?
Oh,
Okay. Brian Brown? All right, ready to start at 8:45.
Yes, good morning.
Good morning. What are you here for today?
George Lindsay, probable cause conference.
Okay. Who's defending the case? Good morning. All right, so we have set a date for March 6th at 10 o'clock for the exam. That's not set in stone as everyone has not zoomed in yet, but that's the date we're starting with, and I will have the clerk send out a mass email to all 10 attorneys to try to get a date. I know for all the rest of the attorneys that checked in, they have paper and the wrong video was sent. Is that your case?
Yeah, I have paper and no video was sent, so I can't even say I have the wrong one. I have none.
Okay, so Mr. Kirker is going to send out the correct video. Is that correct, Mr. Kirker?
Yes.
Okay, so he'll send out the correct digital. My question next is, do you need to go on the record for this case?
I mean, it's up to you. I mean, I can go on the record, or I cannot go on the record.
I don't need to. It's up to whether you want to put it on the record.
That's fine.
Case number 2355480, people of the state of Michigan versus George Lindsay. Defendant number 6, charged with one count of police officer assaulting, resisting, and obstructing. Today is the day set for probable cause conference appearances.
Alexander Kirk on behalf of the people, P862.
And good morning, Brian Brown, P80560, appearing on behalf of Mr. George Lindsay with permission to waive his presence for today's hearing.
Thank you. And as you just discussed, you have paper and no digital, and Mr. Kirker stated that he will provide digital to you today. Is that correct?
Yes, Your Honor.
Okay. We have a date set at March 6th, 10 a.m., which may be changed based off of the availability of all attorneys. And the court will send out an email with all the attorneys on thread to try to get a date for the exam. Is there anything else?
Nothing further from the defense.
Okay, all right. Look out for that email. Have a good day.
All right, you too. Thank you.
Is Attorney Burrell ready on her client's case?
No, she apparently has a deadlocked jury, so she had to go across the street.
Oh,
So she'll be back.
okay. All right. Attorney Colasa? Division 2, good morning.
Good morning, Your Honor.
How you doing
I'm gonna
today?
have, morning, I'm gonna have 4 people from this location. It's gonna be Perry, Cook, Coppins, and Miller from this location.
Okay, so we did Terry, Miller, and Coppins already. The attorneys waived their presence, and we set a date for an exam that may change based off, because it's a 10 defendant case, we have to get an actual date with all the attorneys on board. So we don't need Perry, Miller, or Coppins, and Cook's attorney is present and ready to go.
Okay, I can grab Mr. Cook and I'll be back in a second.
Okay, thank you. Attorney Colasa, good morning.
Good morning, Your Honor.
Did you hear, you're getting your client now?
I heard. Thank
Okay. To the person with the device, the Lero 5G, can you unmute your device and state your name, please?
Which room?
The person without their camera on, can you please unmute your device, turn your camera on, state your name? Mr. Harris, can you state your name, please?
That's state your name.
Curtis Harris.
Okay. You change your name on here, that Harris. It's a 2 No. I think Curtis. Oh, okay, so that worked out. Mr. Harris, your attorney already called in and checked in and set a date for your preliminary examination. You're about 40 minutes late. Your case was called at 8:30.
4 hours on the paperwork.
Mr. Harris, your exam date will be March 1st, 8:30 a.m. in person at 36th District Court.
Oh, that's when I gotta go?
Your exam date will be March 1st, 8:30 a.m. in person at 36th District Court. You can call your attorney for more details, okay?
Okay, all right.
All right, anything else?
No,
Okay, just call your attorney that he or she can give you more details, okay?
I don't even know who my attorney is.
Okay, let's see. Oh, okay, you're the person, your attorney actually was looking for you. He didn't have a good number for you. Can you provide your phone number to the court?
I just got my phone. I don't know my phone number by heart.
Okay, I'm gonna give you your attorney's number and you need to call your attorney as soon as possible, okay?
Okay, let me find a pen.
All right.
Okay, I'm ready.
Okay, now we're not ready. We're trying to find the number.
734
734
281
281
7100.
7100. And what's his name?
Carmen, Karman.
Carmen. Because I never met anybody.
That's fine. You have an attorney. That's what's important. So call him now. As soon as you get off, log up now and call him because he's been looking for you. He's been trying to find you to talk to you.
Okay.
All right. You have a good day,
So
there.
everything good?
Yeah, just make sure you show up on the 1st at 8:30 in person at 36th District Court. He will explain that in more detail. But
Okay.
you don't have to put it out. You showed up. We got your attorney number to you, so you call him. You all get your strategy together for March 1st. Okay.
Okay, thank you. You have a good day.
Sure.
Your Honor, here's Mr. Cook.
Okay, thank you. Okay, this is case number 2355480. People of the State of Michigan versus Brandon Antoine Cook, who is defendant number 4 on this case. Is charged with 1 count of police officer assaulting, resisting, and obstructing. Today's day set for a probable cause conference appearances.
Alexander Fricker on behalf of the people, PD 6282.
Good morning. Attorney Scott Colossus standing in for attorney of record Brent Jeffrey P84583 on behalf of Brandon Cook.
Can you say, one more time, your audio went out?
I apologize, Your Honor. Good morning, Attorney Scott Colossus standing in for attorney of record Brent Jeffrey P84583 on behalf of Brandon Cook.
Thank you. And we've had 6 attorneys check in on this case so far. We may have an issue with the exam date that I set for March 6th at 10 a.m. But the court will send out an email to get a better date. All the dates don't. The date doesn't work for all the attorneys. So I guess the next question, do you have discovery?
We do have the paper discovery, Your Honor. Mr. Jaffe asked that I come on here and stand in for him just to set the case for exam.
Okay, Mr. Kirker, is it correct you're going to send over the digital as well?
Yes.
Okay, all right, so it's March 6th at 10 a.m. And if that date doesn't work for all the attorneys, we will try to get another date. An email will go out today asking to make sure that that date works, okay?
Yes, Your Honor. I will direct Mr. Jaffe to respond to that email. It does seem that that is a Jewish holiday, so it may or may not work for Mr. Jaffe. I'm not sure if he's working that day, but I'm sure I'll remind him to respond.
Okay, and Mr. Cook, good morning to you.
Good morning.
Can you state your full name for the record, please?
Brandon Antoine Cook.
Okay, did you understand what just happened or everything that we're discussing?
Yeah, I understand.
Okay.
So we
all right.
So I don't have no court date March 1st?
No, I do not see him. For me, no, not in courtroom 438, Judge Sabree, you do not.
Okay.
So we have it set, oh, I see, it was just automatically set for March 1st, so that date is taken out and we're setting it for March 6th for now.
Okay. Okay.
All right. All right, anything else?
Nothing from the defense, Your Honor.
Okay, nothing for the people?
Nothing from the people, Your Honor.
All right, you all have a good day.
Thank you, Your Honor.
You're welcome. You're all set, Mr. Cook. We don't need Huff. Huff we already did. So the only. I know, I'm sorry, Judge.
Lindsay, Defendant 3, Defendant 6.
Okay, I'm gonna tell you, we only need 3, 5, 7.
Let me try.
Because everyone else, their attorneys already set their date. So 3, 5, 3, 5, 7. Actually, Mortimer Miller already did his too. Mortimer, we already did it. Attorney Mortimer.
Yeah, that was Miller.
Yep, so we don't need 7.
Yeah, I don't remember which one is record.
Oh, wait, let me see. Yeah, we did. That on the record.
You said it was on the record?
Yep. With the tiny brown lot, the other lot. Remember you said, well, you want to go on the record.
Oh, I was like, oh, I'm sorry.
So we need 3, 5, 3, 5, 9.
Okay.
Yeah, I'm glad you brought these up.
Good morning, Judge. How are you?
Fine, how are you? Good. I didn't realize we had a 10-50 case for PCC today, all of them.
Oh, okay.
We're ready to go.
Defendant.
10-50.
Sounds like federal court.
Right, they can go ahead and take it. I think it's a jail case, so something like that. All right, so let's get. What's your name, sir?
Arguable.
There's a problem with this, sir. All right, everybody ready on hold?
Yes.
Yes.
We're on the record as the people of the state of Michigan versus Isaiah Hall. Hall is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons, felony firearm, count 3, malicious destruction of personal property, $200 or more, but less than $1,000 with an habitual offender fourth offense notice. This is case 2259537. Today's day set for preliminary examination appearances.
Morning, Your Honor. Eric Duggar, PA 5931 for the people.
Good morning, Your Honor. May the court, Virgil Johnson, appearing on behalf of Isaiah Hall, P46646.
And Mr. Hall, can you state your full name for the record, please?
Judge Arnold.
And are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
The mutual sequestration for any and all witnesses with the exception of the officer in charge, Your Honor.
Any objection?
No objection.
Oh, I see. Okay, so for the record, there's no one else in the courtroom other than defendant, both attorneys, prosecutors, and staff. So with that, the people call the first witness.
Thank you, Your Honor. The people call Devin Horn.
You swear to tell the truth, the whole truth, and nothing but the truth. Yes, ma'am. Have a seat right here. Put the words right in front. And make sure you speak up in the mic. You can hold it in your lap. Whatever you're ready to say.
Good morning. Please restate your name for the record, sir.
Devin Horn.
Make sure that the microphone's pointing right here.
Devin Horn.
Okay. So let me take you back to the day of May 28th of 2022. Do you remember that day?
Yes.
Okay. Now, are you familiar with the address 18450 Marlowe in the city of Detroit and County of Wayne?
Yes, sir.
Okay. What is that? What's the significance of that address?
The address is where Mr. Hall and his family was residing.
Okay.
And the girlfriend, Carlotta, was there for a short period of time as well.
Well, let me take it. Let's step back just a second. When you say, Mr. Hall, do you know? Is there anybody you recognize in court today?
Yes, sir.
Okay, maybe you could point them out and tell me something that they're wearing.
A t-shirt, Mr. Hall.
Okay, so just for the record, Your Honor, the witness has identified the defendant, Mr. Isaiah Hall. So we were talking about May 28th of 2022. Could you, is there anything unusual that happened that day that brought you to court today?
Yeah, situation escalated when my girlfriend was treating her TV.
If I can stop you just for a second. When you say situation escalated, how did that start?
It started with us going to the house to retrieve her clothes and a few items.
You went to whose house?
To Mr. Hall's house.
Yeah, to the defendant's house? Oh, okay. So when you went to the defendant's house, but then what happened?
We went there to retrieve a few items, clothes and TV and things like that, because we were moving. So.
Oh, but why were you retrieving them?
Because we were moving.
Okay.
So we were gathering her things to take over to where we were moving to. So,
okay. So what happened after you arrived?
Judge, I'm asking to let the witness finish his statement.
Okay.
Okay. I know. Okay, go ahead.
So yeah, we was retrieving items to move, to where we were going. So when she finally went in and grabbed the TV, that was the final thing that she wanted to get out of there. When she grabbed the TV from there, the situation escalated because I guess Isaiah didn't want to let her have the TV. I'm objecting to speculation, Judge.
Any response?
No, Your Honor.
Okay, so sustained. The witness can't speak to what his girlfriend thought his defendant wanted her to do.
Yeah, can I ask you, when you say her, who do you mean?
Carla.
Who's that?
Carla.
That's your girlfriend? Okay, so let's get back to what happened. So you arrived at to pick up a TV, then what happened?
It was TV and clothes, different items.
Okay.
And when she grabbed the TV out last, she had brought it to me, because I had put it in the back of my vehicle. So when I put it in the back of my vehicle, it was an issue between them two with her getting the TV. So that's the issue,
when you say an issue, what does that mean?
Back and forth, altercation, back and forth, like arguing back and forth. It was some sort of back and forth between them two.
Okay.
Because by that time, when I put the TV in my car, I didn't know there was an issue. So I ended up driving off maybe like 30 seconds before she actually called me. So by the time she had called me, she called me and told me her windshield was already cracked. And so now the windshield was broken. So I ended up asking, like trying to ask you what happened, I had just left. I don't know what happened.
Okay.
So I told her like, okay, meet me back over there, because I was literally maybe a block and a half away, because I just left, literally just left.
Okay.
So I was like a block and a half, 2 blocks away. So I just told her, meet me back over there. I don't know what happened. Meet me back. She was on the phone straightening in my ear about windshield being broken. So
okay.
I pulled back up to the front of the house, and he was on the porch. His girlfriend was on the porch, and his kids were outside.
When you say he, who do you mean?
Isaiah.
Okay.
He was on the porch.
Okay.
And I had got in the car, and I asked what happened, because this is before Carlotta pulled back. She didn't come back yet. So I asked her, what happened? What happened? What did I miss? He was telling me like it was nothing that really happened. I could tell it was an issue, but he was kind of like, it's nothing. And his girlfriend was telling me, oh, well, I need to leave it just between them two, just to let them two have the issue.
I'm object to the hearsay.
That would be hearsay.
Yeah.
Unless you have an extension.
I don't know. So yeah, just what did you do?
I was trying to ask her what had happened, because I didn't know. I'm trying to talk to her, what had happened. She said her windshield was cracked.
If I may, just simply tell us what the defendant said, okay?
When he was just telling me that he was just like irritable about whatever. He didn't really tell me exactly what happened.
Okay.
So then Carlotta proceeded to come back, pull back into the driveway. So that's when I seen her windshield was cracked on the driver's side.
Okay.
So I see the windshield's cracked. I'm now asking like, what happened? Why did you crack the windshield? What happened? Then he turned his focus to her, to Carlotta, and they started going back and forth, barking back and forth, cussing each other out, things like that.
Okay.
I'm telling her, Carlotta, to stop, and because I was trying to talk to Isaiah, so I'm telling Carlotta to stop, chill, relax, whatever. Yeah, I'm trying to talk to Isaiah about what happened. There was no issue between me and him.
Okay.
Never was an issue between me and him. We never had any prior history issues, nothing like that.
Okay.
So I felt like we was able to, talk, have a conversation. So
okay.
After they brought back and forth, Carlotta ended up driving, put it back down the driveway.
Okay.
And by that time, Isaiah walked back into the house.
Okay.
He walked back into the house and came back outside, hands in his pockets.
Okay.
I don't know how long enough, I know what that means.
Okay. So when he had his hand in the pockets, what did you think that meant?
Oh, I know what it means. He had something in his pocket. It was, I'm sorry, that wasn't speculation, because I know how to read.
Hold on, there's an objection on the floor against that. I know you want to tell your story, but you have to let the lawyer figure it out. What's your response?
I don't think it's speculative. I think it's based on his life experience of what happens when he sees somebody with his hand in his pockets. Anybody who would, was ever seen an argument, and then all of a sudden you see somebody put their hands in their pockets. Usually that means that there's something in the pocket that maybe they want to use in the argument of that.
You can speak to what he thought it was.
Okay. Okay. Okay, go ahead. So then after you saw his hand go in your pocket, then what happened?
So then I started to walk backwards towards the car, because I know from my prior experience with law enforcement, from Wayne County Sheriff, I know with my prior experience in security, I know you don't turn your back on situations like that. So I'm walking back towards my car, because I see that he's escalating and his hand is in his right
Judge, I'm
pocket.
object to the narration. I mean, I've kind of backed my objections and stuff, but he's just narrating now. Gotta ask a question.
So there has to be a balance here because the
Yeah.
first objection was allowed to cut him off. So just, Mr. Decker, make sure that this doesn't go on too long.
Okay, I will see if I can find the middle ground. Okay, so, let's just go back to, so you said that you were backing up.
Yeah, I was
Okay.
walking back towards my car.
So then, all right, so after you're backing up, then after you started backing up, what did he do?
He's started getting louder, more aggressive.
When you say violent, you're talking about just through his words?
Yeah, through his words, his body language, his movements. I noticed.
Okay, so did anything happen after that?
When I got into my car, I see him pull out of his pocket a firearm.
A firearm, what kind of firearm?
It was a handgun.
A handgun?
Yes, sir.
What did the handgun look like?
It, like black, the black handgun. I don't want to give a specific make and model.
Okay.
Because it could be any kind of black handgun that could be in play.
Okay.
It was definitely a handgun that he pulled out of his pocket.
Okay, what did he do with the gun?
When I got in my car and started driving off, he pulled his handgun up and aimed at my car on my side with me and my son.
Okay, so, was he pointing the gun at you?
Yeah, he's pointing the gun at my side of the car.
Okay, so then after that, what happened?
I had drove off and I had called Carlotta to figure out where she was, what she wanted to do. And I told her what had happened. And she told me to come to the police station and file a report.
Okay, did you observe any damages to any car?
Yes, Carlotta's windshield, yes.
Okay, did you see at any point, how did you know that it was? So just describe the damage to the car.
It's on the driver's side at the bottom of the windshield and it spread upwards throughout the rest of the windshield. The damage started at the bottom driver's side.
Okay. Nothing further.
You indicated that you had no bad blood with Mr. Hall, correct? And you were there to back up Carlotta, correct?
Yeah.
And you heard Mr. Hall, you saw Mr. Hall come in and out the house. You all were able to move the items out the house without any incident, correct? And after that, you left the premises, correct? In your vehicle,
Yes.
correct? And Carlotta, Miss Trent, left in her vehicle, correct? Without incident, yes?
No, they said had occurred with her wish.
Wait a minute, sir. Let me understand the question. When you left the premises, you left in your car, correct?
Yes, sir.
You didn't see when she left, or did you see when she left?
No, I didn't see what she had.
Okay, so at some point you learned she left, correct?
Yes,
Without any issues, correct?
it was an issue.
You didn't observe any issue, correct?
He admitted to the issue.
Sir, answer the question. You
Did I
did not,
observe it?
I'm gonna ask you the question again, and I'm not gonna argue with you. If you don't understand the question, tell me and I'll repeat it. When you left the premises, I want to talk about what you personally observed. When you left the premises, you didn't observe any issues, correct?
No, I didn't.
You didn't see him break a window, correct?
No, sir.
Okay, so you don't know who broke the window, correct? Yes or no?
That's an act, no.
You
Yes,
don't
I
know
do.
who broke the window. You
Yes, I
didn't
do.
see that, correct?
Yes, I do.
Sir, I'm gonna ask you one more time. I'm gonna ask you one more time, just gonna ask you. You did not see who broke the window, yes or
I
no?
did not see.
Okay, and at some point, she informed you that her window was cracked, correct?
Yes, sir.
Okay. And it's your conclusion, based on what she told you, that he broke the window, correct? Yes or no?
No, that's an act.
Okay,
Okay,
well,
I'm gonna test.
I'm gonna move
He was
on,
not
sir.
there, so I know he didn't see it.
I'm gonna move on. At that point, Carlotta came back, you came back, correct?
I can't wait. Then she came.
Yes, and that's when There was an argument, correct?
Yes, sir.
Okay. And you had no reason to be on the premises, correct?
No.
Okay. And he asked you both to leave, correct?
That was after this.
I didn't ask you that.
Yes.
I said he asked you both to leave, correct?
Right.
And you refused to leave, correct? Because you were there to support Colada, right? Yes or no?
I was there for the sir.
Sir, can
Yes,
you
yes,
remove
yes,
your
yes.
mask? I can't understand what
Yes.
you're saying.
Yes.
How about?
Here's one.
Okay, and at no time while you were arguing with her, with him, before he went in the house, did he produce a handgun, correct?
No.
And then you say he came out the house, correct?
Yes.
With both hands in his pocket, correct? And you didn't see him pull a handgun at that time, correct?
No, sir.
Okay, and so you proceeded to get into your car, correct?
I was able to walk to my car. Yes.
Yeah, and
I was able to walk back to my car. Yes.
yeah, you turned your back to him, correct?
No.
Okay, you didn't walk towards him, correct?
No, I walked backwards.
Okay, you walked backwards to your car.
Yes.
Where you had a weapon, correct?
Yeah.
Okay, and you told the police you had a CPL, correct?
Yes, sir.
Okay, and you had that gun in your car, correct?
Objection, relevance.
I'm gonna connect the relevance. You had a gun in your car, correct?
CPL, yes, sir.
I didn't ask you that. I asked you, you answered that. I said you had a gun in your car, correct?
Yes, sir.
Okay, and you sat in your car where your gun was, right? You got in your car, yes or no?
At what point?
Did you get in your car, yes or no?
I got in my, at
Can
what
we
point?
clarify?
You said you walked.
Attorney Johnson, can you clarify?
I'll rephrase. You said you walked back to your car.
Yes, sir.
And you got into your car, correct?
Not all the way. I was sitting
I
outside.
didn't ask you that. Did you get in your car, yes or no?
No, sir.
Okay. You reached in your car.
No, sir.
Well, you just said you went into your car.
I said I'm back to my car.
Okay, did you
And
get
when
in
I
your
got-
car?
when I got-
Did you get in your car?
To leave, yes.
Okay. And that's where your gun was, correct?
Yes.
Okay. And your gun was concealed, right?
Yes.
And that's when you indicate he pulled the gun on you, correct?
Yes, sir.
When really you pulled the gun, correct?
No, I didn't.
Okay. No further questions.
Nobody here, Your Honor.
Mr. Moore, you can step down. No, leave it on for the next person. Do the people have any other witnesses?
Yes, the people called Carlotta Trent.
Right here. You swear to tell the truth, the whole truth, and nothing but the truth. Right here. And you hold the microphone in your lap, if it's easier, but just make sure. You do it. Okay. Whenever you're ready.
All right, good morning. Please restate your name for the record.
Carlotta Trent.
Now let me take you back to the day of May 28th of 2022. You remember that day?
I do.
All right. Do you? Is the address of 18450 Marlowe in the city of Detroit, County Wade? Is that? Were you there that day?
Yes, I was.
Okay. Does that address sound familiar to you?
Yes.
All right. What is it?
It's the address of Isaiah Hall, and it's where I used to stay here.
Okay. Now, when you say Isaiah Hall, is there anybody you recognize in the courtroom today?
Isaiah Hall.
Okay. If maybe you could point him out and tell me something he's wearing.
Black shirt, green color.
Okay. So, Your Honor, may the record reflect that the witness has identified the defendant, Isaiah Hall. Okay. So, on that day of May 28th, was there some kind of was there anything that happened on that day that brings you to court?
Yes.
Okay. Could you maybe describe what happened?
So what happened that day was I was coming in my belongings. We were supposed to be moving to a new apartment.
You say we, who do you mean?
Me and Devin's boy.
Okay. Who's he?
He is my boy.
Okay. So then what? So what happened?
So we were moving my belongings. I had a tote and my TV was there as well.
Okay.
I went to go get my tote and my TV. Isaiah Hall didn't like that, so we did get into a back and forth conversation, which led to us getting into a fight.
Okay. So did you just get an argument and that was it?
No.
Okay. What happened after that?
And my windshield was cracked.
How was? Sorry. What did you say?
We got into an argument and my windshield was cracked.
How was your windshield cracked?
It was cracked at the driver's side at the bottom, and it was shattered all the way through to the top.
How did it get cracked?
It was hit by Isaiah Hall.
Did you see him hit it?
No.
Okay. So why did you think he hit it?
He admitted to hitting my windshield.
Oh, okay. So how did that conversation go?
So when I realized that my windshield was broken, I confronted him about it, and he said, since you wanted to take your TV back, I broke your windshield.
Okay. So then what happened after that?
So after that, I drove off, and on my drive off to go to the police station, his girlfriend called me, and she told me, I'm sorry, but you're gonna have to put on a black dress, because I'm gonna go ahead and have somebody do something to them.
Okay.
I'm objecting to hearsay and irrelevance.
Stated by a co-conspirator, Your Honor.
There's lack of foundation for that.
Yeah,
Okay.
so I'm going to sustain that.
Okay. So then what did you do after that?
We went to the police station and make a report.
Okay. All right, nothing further.
Morning, man. So you were moving items on that day in question, you're using your vehicle, correct?
Correct.
And you were someone called the police, correct?
Correct.
And when you gave a statement to the police, correct?
Correct.
And at the time you gave that statement, they told you that they wanted the facts relating to the case, correct? What happened? Right. And you're a mature woman, you understood that everything that happened, they wanted you to tell them at that point, right?
Correct.
So they could understand what he did wrong, correct?
Correct.
And they wanted everything, you understood they wanted everything that you personally observed, correct?
Correct.
you understand the importance of reporting those facts at that time, correct?
Correct.
And you told them everything you knew then, correct?
Correct.
As it relates to your vehicle, you never saw Mr. Hall approach your vehicle with a brick or a rock or an object, correct?
Correct.
You never saw him throw a metal object or any object at your window, correct? You never saw him intentionally walk up to your vehicle and break or crack your window. What you do know, or what you claim, well, at some point, after you move your items out of the house, you and Mr. Horn left in two separate vehicles, correct? Correct. Okay. And it was at some point you discovered your windshield was cracked, correct?
Correct. While there, on the scene, correct.
And you called Mr. Horn, correct?
Mr. Burrows already there.
Well, you
Happened while we were
you
there.
both returned in two separate vehicles,
We didn't
correct?
return in separate vehicles, we showed up in separate.
Okay, my question is simply, ma'am, you had already indicated you both left in two separate vehicles, correct?
Correct.
Initially. My question is simply, at some point, you both returned to the premises, correct?
Correct.
Okay, and when you returned to the premises, you and Mr. Hall began to argue at some point, correct?
We argued before pulling off, and that was stated in the statement.
Okay,
That
I'm
was
not,
stated today in the report.
ma'am,
We asked me the question first.
ma'am, I'm gonna ask the question, okay?
Ms. Trent, just make sure you answer the question. This is yes, no, this is yes, okay?
My question specifically deals with what happened when you returned. You understand? So
Excuse me.
when you return,
Can I be excused because it's the pointing and all of that,
I'm sorry, the what?
the pointing and all of that, I'm not gonna do that.
That's point, what point?
From him,
From the defense counsel?
yes.
Okay, so you can't be excused. I'm not sure, I didn't see it, so I know this may be frustrating for you. But the prosecutor will have an opportunity to put up any questions that you may not be able to answer based on the testimony, okay?
That's not fast.
And that's what I'm going to do, right?
Thank you.
it's kind of frustrating when you're lying, correct?
Objection.
Objection, what's the objection?
It's a form. That's a form. He's drawing a conclusion, he's testifying.
No, I'm
Argumentative,
What's that?
I believe it was argumentative, but.
Yeah, it's argumentative.
So
So,
rephrase that question.
yeah, so when you went to the police, you told the police that Mr. Hall broke your
That is
windshield, correct?
Correct.
In fact, you told him, the police, that he broke your windshield with an unknown object, correct?
Yes,
That wasn't quite the truth, correct?
it was the truth.
It was a conclusion on
It
your
was the
part,
truth.
right?
It was the truth.
But it
It
was
was the
also a conclusion on your
It was
part,
the truth.
correct?
So I believe
It
it was
the
asked
truth.
and answered, she said it was the truth based off of her testimony.
So your truth was actually based on some words that you said, he said, and not what you saw. Is that correct?
His admittance,
Is that
yes,
fair?
that's correct.
Okay. You indicated you saw Mr. Hall pull a gun, correct?
Correct.
Well, you never told the police you saw him pull a gun, correct? Correct?
Correct.
Okay. Because you didn't see him take a gun out of his pocket or pull a gun, correct?
You're correct. I wasn't there for that incident.
So you didn't see him pull a gun.
Correct.
You didn't see him point a gun.
Correct.
Nothing further. Oh, wait a minute. I'm sorry. I apologize. One more question. So again, when you told the police in your statement that you saw Isaiah point a black handgun at Devin's car, that was not true, right?
That was correct. Thank you.
So.
It was correct.
So today you testified that you didn't see him point a gun, but you told the police, which they used in the
Well,
charge.
my statement is true.
Yes, we both can't talk at the same time.
You're right. And I thought that you were done asking questions.
When you told the police that you saw him point a gun, that was not true, correct?
It was true.
So which one do you want the court to believe today? That you didn't see him point the gun, or you did see him point the gun?
You did, and I'm not answering more questions.
Well, actually, Ms. Trent, that's not how it works here today. So, I do too. But I can't. So the question is that what you put in your statement, is that correct? Okay, it is also correct that you stated for counsel that you did not.
I did.
Did not or did?
I did.
You did. Okay, any questions based on that?
No, Your Honor. So you're not being quite truthful.
I am being truthful.
Okay. Well, you weren't being truthful.
I am being
Police.
truthful.
Okay. Thank you.
Nothing further, Your Honor.
Okay. You're done. You step out and go to the hallway.
No, Your Honor.
You for defense.
No.
Okay, all right.
The legal motion for bind over to circuit court, it's a question of fact has been established and we reserve time for argument.
Okay. I have it.
I didn't get a copy.
We'll talk.
Here
You got it? No problem.
Judge, with respect to the malicious destruction of property, based on the testimony that was elicited today, I don't think the prosecution has met its burden that my client willfully and maliciously destroyed personal property of Aliyah Trent based on her testimony, as well as the testimony of the Mr. Horn. Neither one of them observed the breaking and the damaging of the property. In fact, based on her testimony with respect to the firearm, I believe that based on the cross-examination, Judge, she really put her credibility in issue and her court can also take her conduct, her attitude, the way she responded to the questions as evidence. And based on that, I have dismissed malicious destruction of personal property. With respect to assault with a dangerous weapon, I don't think that there's been any evidence that, I mean, we could say it was a question of fact, but I don't think there was any evidence that this gentleman was ever placed in fear from the pointing of the gun. He indicated that he was a CPL holder, but his testimony got inherently, I don't want to say inherently incredible, but his testimony was questionable when he talked about getting back into the car, where his concealed weapon was. He vacillated. First he said he walked backwards to the car. He said he got in his car prior to that, but then when I asked him, did he get into his car when I suggested that I knew he had a weapon inside, he vacillated. So the judge, you may want to call it a question of fact, but he doesn't appear to be that he was placed in apprehension of fear. I think this whole case should be dismissed because I think they both went to the police department, manufactured the facts, and he's the one that had the gun, and it's just to protect them from my client going in and actually asking for charges to be lodged against them. I know this is not a trial, it's a preliminary exam, but I was just basically giving the foundation of my theory. Thank you.
Yes, Your Honor. So on the malicious destruction of property question, yes, we do agree that it's true that that was not seen, but defendant did actually say we heard in testimony from her, from Ms. Trent, that specifically, the defendant did say to her, not only that he broke the window, but actually also gave her the reason why he did it, because he was upset about about the situation with the television. So not only did he admit to it to the witness, but he also said exactly why he did it. As to the question of the assault with dangerous weapon, the felonious assault, and the felony firearm, the question there, I agree with defense counsel that there is a question of fact, so therefore it is ready to go over to circuit court and be placed in front of the trier of fact. But we heard the testimony specifically from Mr. Horn that a gun was pointed at him as he was driving away. That, I believe, meets the elements of the crimes that have been charged, and it's ready for this to go to the third circuit court. Thank you, Your Honor.
And Judge, I don't think testimony from her was that why he said it. She just said he said he did it.
Quite aware. So I just heard from two individuals, the court, Mr. Horn and Ms. Trent. I'll start with Ms. Trent. I do not believe her. Her testimony was credible in this case. Had she not continued on stating that she saw the gun pointed at Mr. Horn, and then after revealing that we're going back and forth whether she did or not, I don't find her to be truthful about that incident, which leads to her statement that the defendant said, since you wanted to take your TV, I broke your windshield. If she hadn't gone back and forth and basically lied, in my opinion, about whether or not she saw the gun being pointed, I would have bound over that count, but I don't find her to be a credible witness. But with Mr. Horn, I do find his testimony to be credible enough, or it is credible, from what I heard, to bind over on counts 1 and 2. And just for the record, for felonious assault, the defendant either had to attempt to commit a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery. I know defense counsel, you spoke to whether or not Mr. Horn was in fear or not, but it's what the reasonable person will believe. And I do believe a gun being pointed at someone would put someone to fear the applicant or to be feared. Excuse me. Second, that the defendant intended to either to injure or to make the complainant with his reasonably feared immediate battery. I believe that counts as bad. Third, that at the time the defendant had the ability to commit a battery, had a handgun. And fourth, that the defendant committed the assault with a dangerous weapon, which would be the black handgun described by Mr. Moore. So I will have Mr. Hall bound over on counts 1 and 2. I will have count 3 dismissed without prejudice for insufficient evidence. And your regular information will be March 8th at Framework Hall of Justice at 9:00 a.m.
Thank you, Your Honor.
I will have that form filled out. Do you have a dismissal form already?
Yes, Judge,
Okay.
I'm fill it out.
Security. Stay ready.
Okay. Okay. Okay, can I have that back on my stack? Get back to ROA. Second, what? The ROA? Oh, yeah. What? Okay, who's next?
Canada.
Okay.
Who's next? Canada. No one's here on that.
So what about Maribel's case?
So she left again.
Oh, okay. All right. What about Rockmore?
Rockmore's in custody.
That's two.
Everybody's here. Everybody's here on that? Yeah. And everybody's
Okay.
here on that.
So candidate is? All right.
Canada. Yes.
So I'll be defendant number 8.
Yes, Your Honor.
You have a warrant out. So. Well, I'm establishing it now. I can figure out why we had 10 defendants on one case. No, I did not. I said all these cases at 8:45 because we didn't have all this. Thank you. Nice handwriting.
Thank you, Judge.
Oh, I'm like, do I look crazy right now?
Yeah.
Thank you, Your Honor. You all have a good day. You and your staff.
Thank you.
You want to stop?
Yeah.
Okay.
Okay. Canada? Okay, we want to make sure we have the right person. Mr. Deckers handling this one?
Probably knows it.
Okay, we're on the record. This is people of the state of Michigan versus Gregory Aaron Rockmore, who's defendant 1, and Reginald Orlando Tarleton Jr., who's defendant number 2. Case number 2355271. Both defendants are charged with 1 count of robbery armed. There's a habitual offender third offense notice for defendant number 1, Mr. Gregory Rockmore. Today's the next step for preliminary examination appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Hey, good morning, Your Honor. May it please the court. My name is Mark Brown. My key number is 39562. I appear on behalf of Mr. Rockmore, who I've asked not to be brought out yet.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Reginald Tarleton Jr.
And Judge, the reason I asked that Mr. Rockmore not be brought out is because it occurred to me when I was reviewing the discovery both with him and on my own, that there is no identification of Mr. Rockmore as a perpetrator in this case. In other words, there was a lineup done, but there wasn't a lineup done with Mr. Rockmore. And if Mr. Rockmore is brought into court today, there are 2 people sitting there. There's previously been identification not of Mr. Rockmore. There's only 1 person left, and that's I don't know how you could define suggestive in terms of identification procedures any other way. So I would respectfully object to proceeding to ask for dismissal because there's no identification of him as a perpetrator. If that's not that, then I'd ask for a lineup.
Now you ask for what?
A lineup.
Anything from people?
Yes, Your Honor. We disagree with the recitation of facts that was just presented by defense counsel. I have the officer in charge right over here in courtroom to my left. She tells me that there were actually lineups done, and one was done with Mr. Rockmore. A lineup was done on the 18th of January, and also another one done on the 20th, and both of those were sent to defense counsel on January 27th.
Well, may I respond? It's very interesting because I got one lineup, did not involve my client, Mr. Rockmore. I inquired of my co-counsel whether she had a lineup for Mr. Rockmore, and she did not. She can speak for herself. But, I don't have a lineup. You can show me the lineup. Do you have one?
So you mentioned the 18th and the 20th. Attorney Brown, do you know which one, or did you receive both of those?
I received one lineup. There were, I think, 6 or 8 people.
Okay.
And that's it. And the only person, my client was not in that line.
Your Honor, the officer in charge who did the lineup is to my left of the court.
Okay. And you're checking on the lineup right now. Okay.
Your Honor, if they did send it out, they might have sent the same one twice because, as you said, I have my lineup for my client, but as they're all in the same one, I do not have his lineup for his client.
For Mr. Rockmore.
For Mr.
Okay, well, let's see. Oh, I see the check on it now. Thank you.
Your Honor, may I speak to this? Another thing? Sure. This was not a quick encounter. This is something that actually went on for what the people believe that the testimony will reveal is this was not something that just happened quickly. This was a long, sustained 20-minute encounter where there was a lot of opportunity for the complaining witness to get a really good look at the people whom he was interacting with. So it seems to the people that there was enough time during the encounter that a lineup wouldn't really be necessary in this case.
Well, with all due respect, I don't know.
I think
He's not a witness. He's not a witness, and I'm saying the APA is not a witness, number one. Number two, it doesn't matter. There's no identification of my client in any documents that they've sent to me whatsoever. So we shouldn't even be here. We shouldn't go beyond and have him sit here and be identified simply because he's the second young black man sitting back there. That makes no sense.
I think the first issue is a matter of discovery.
Mhm.
So once we get to what's going on with the lineup, this, what it looks like, then we can move on.
Okay.
I think this is important.
Okay. And I also think it's important that whatever time we started talking about this, we still don't have a lineup held up by anyone here. Okay.
Oh, we do. I got it.
Okay. Okay.
Oh, yeah, we can draw it.
It's in my car.
Okay.
You got some?
It's in my car.
I can address this. Okay, so from what I just have been told is that apparently the second lineup does exist, but was not sent to defense counsel. So if he's going to, Mr. Kirker is going to upload it right now and send it over. If the court feels it's necessary for an adjournment, then I understand, but at this point, the people feel like we can proceed without it.
I know the people probably,
Yes.
at minimum, an adjournment, depending on what the second lineup looks like. If it exists, it has its line in it, I will grant adjournment, so I look at it. But if there's no definitive lineup, then that's another issue.
Right. The officer in charge assures me that it exists.
Definitive,
With the defendant?
correct.
Correct.
Then I move to dismiss for breaking violation or violation of discovery. I'm joking, but I'm not joking.
Well,
Very, very serious.
I hear you, I understand.
Yeah.
So I keep saying, based off of what's happening here, I don't believe the people were withholding discovery. But I don't want to testify and say what they did and what they didn't do. But it seems to me that officer charged did have it.
Yes, ma'am. So the representation initially was, we don't need it. So if there is one, and actually the representation made not by this council, but someone else, representation was made that there was no lineup. And then all of a sudden there is a lineup, and then we sit here for however long, I'm not for about a minute.
No,
It goes on for, it's not like, oh, here it is, I pull out my file and give you a copy of that. No, we look and find now that there's miraculously a lineup. So that's why I made, even though I was chuckling, I'm not laughing and joking.
Right, discovery is a serious issue.
It is very
If
serious.
it exists, it needs to be provided.
Yes, thank you.
I agree.
So,
Just wait until it's sent.
that has been sent.
Hey, Miracle, I'm sorry. That's okay. We had 10 defendants, PTC this morning, it was not on the docket. when I scheduled it.
That is okay. I have a verdict out across the street. I started a new trial in Grand Rapids. They on motion today, so I'm just blessed for the downtime.
Okay. I think yours gonna be whole, probably.
They're gonna be whole. One of my clients is here and everybody's here. The other one, I don't know. My client's not
Is that
here.
ACOP?
What?
ACOP is here?
ACOP.
Okay, cool.
Okay.
Did you have to tell the attorneys to set up? Yes. What they say?
Yeah, I just talked about my phone. Oh, okay.
Yeah, second one show.
Your Honor, it has been sent apparently. Do we need to see it today, right now?
I think Attorney Brown does.
You want to see it today?
I guess that's your suggestion that we adjourn, exam.
Is that what we're leaning towards?
So it's up to Attorney Brown what he would like to do. If he can look at it and decide if he wants to go today or if he wants to adjourn it, that's up to you. That's up to you.
Well, I'd like to look at it, number one, but I also like to look at it with my client, number two. And number three, I think I'd like to address the bond. Because we're here, we shouldn't be here without an identification of the defendant and the perpetrator by the person complaining that never occurred in my case. So I'd like to address the bond and perhaps another day.
Well, can you check the lineup to see if you have it first?
Could you show it? Yeah, please. Okay.
Cover on side. You just did. Stuff with them Germany, we do it.
We can show it. Yeah, show it. So, Dad, just speak to my client.
Yeah, he's. We adjourn. Are you getting ready to talk, show you something now or?
Yeah, maybe we should adjourn. It's all right.
They're custody, so I want this to be adjourned quickly.
And they should be out here, you know, where's the plane?
He's in the witness room.
Let me get a date first.
Let me just go make sure with my complaining witness that he's available on the day that we decide.
Friday.
11?
What you need, Alex?
Friday.
What do you need?
Okay.
Copy that.
Some more blue sheets?
Well,
What you need, blue sheets?
No.
I can do that.
Friday 11.
Friday. Okay, almost there.
Friday 11 fine.
Check the Friday witness.
You want a tissue?
That's it.
Can you put that?
No. That's my first time out there.
Friday 11 works, Your Honor.
Okay. Bring it up. Okay.
Okay, thank you, sir.
Okay, in the toilet, just stop it up. and pull it. Well, we'll set it up here.
There you go.
All right, you can be heard. Yes, but I have to spray it here.
Why?
Like, why you?
Oh,
It's a gift.
Mr. President.
Why do you not accept? Roger, back here. We'll be going to call Ware. Get the Ware. Got a waiver on Wiley?
No.
It was the paper towel, okay, use the paper towel, put it in there. Okay, thank you. Okay, I don't need no excuses, let us know when you're ready. You ready? It's hand sanitizer.
You don't mind just standing in the first row? Okay. All right. On the record, with the people of the state of Michigan versus Timothy Anton Wiley, case 2355325, Mr. Wiley is charged with one count of embezzlement, agent or trustee, $1,000 or more, or less than $1,000. They say that for preliminary examination appearances.
Good morning, Your Honor, Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Nancy Kasser from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Wiley, number 80549.
Good morning, Mr. Wiley. Thank you for that correction. Thank you. And it's my understanding that your client would like to waive his exam today?
Yes, Your Honor.
Any objections for the people?
No, Your Honor.
I got it right now. Okay, Mr. Wiley, I'm going to ask you a series of questions, okay?
Okay.
One, is it your wish to waive your preliminary exam today?
Yes.
Okay. Do you understand you have a right to a preliminary examination?
Yes, I'll.
Okay. Do you understand that if you were to hold your exam today, people would have to prove as a probable cause standard, the lower standard, beyond reasonable doubt standard, that the charge I just read was committed in the city of Detroit, that you probably committed that crime?
Yeah.
And by waiving your exam, that means that people do not have to prove anything today to be bound over to Thursday. You understand that?
I understand.
Did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you anything for you to waive your exam? Okay, I find your waiver to be freely, voluntarily, understandingly given, so I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for a waiver on the information, March 8th at 9 o'clock. Okay? March 8th at 9 o'clock. Anything else?
Nothing else. Thank you, Your
Okay,
Honor.
thank you. Mr. Decker, I need you to sign it.
Hey, that was yes.
Okay.
Okay.
Yeah.
No, he done. You're welcome.
Sledge is actually also going to be able to do it. As we dismissal, will be up for anything from any witnesses. License that, yeah.
The lawyer here? Oh, it's good. Attorney to Dismissal. Is the officer Williams?
Yes.
Nope, I'm just gonna ask you to grab Attorney Castro. Attorney Castro, you come up, you can do your other case, pledge.
Are we,
This is dismissal.
I'm sorry.
This is dismissal, pledge.
Oh, okay.
Here you go.
Your client, he's here, right?
He's in custody.
Let me just double check to make sure that I don't have anyone. This is, I'm pretty sure.
Yeah.
Just double
okay.
check.
In custody, I'm sorry, it's a different story, but it will be.
Okay.
I believe it's dismissal. I just put it right here.
Okay. Case number 2305. 524.
701. And that, step up. I bring them out one at a time, get a fight. Fight on it. You got an attorney?
Marcus, right, what are you doing?
Yes, thank you. Yes. Sledge confirmed.
Okay. The sledge will be next. We'll bring it.
Oh, I got you.
After we get done. Yeah. Okay, we are on the record as the people of the state of Michigan versus Gregory Aaron Rockmore. Give you one more. Oh, and Reginald Orlando Tarleton, case 2355271. Both defendants are charged with one count of robbery armed with a habitual offender third offense notice for defendant number 1, Mr. Rockmore. Today's day set for preliminary examination appearances.
Good morning, Your Honor. Eric Decker, PA 5931 to the people.
And good morning, Your Honor. May it please the court. My name is Mark Brown. My P number is 39562. I'm here on behalf of Mr. Gregory Rockmore, who's president of Mr. Rockmore Station. Please, sir. Gregory Aaron Rockmore. Thank you.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Reginald Tarleton Jr., who's standing behind me.
Reginald Orlando Tarleton Jr.
Good morning to you, sir. All right, so we have some preliminary issues regarding discovery. And it's my understanding we're going to have the adjournment. Is that correct?
That's correct, Your Honor.
Okay, we've agreed on the date of Friday, February 24th. Okay, anything else to address?
No, I wanted to address Don, but I'll wait to address it on Friday. Thank you.
Okay, so, Mr. Tarleton and, it's Tarleton, right? Okay, Mr. Tarleton and Rockmore, I will see you on Friday at 11 a.m. We should be able to hold the exam then, now that your attorney, Mr. Rockmore has what he needs to hold, okay? And also bond will be addressed, okay?
Thank you very much, Your Honor.
You're welcome. You want to copy the issue report?
Yes, please.
Okay, right. Attorney Brown, we have the issue report. I start with the rest of it.
Thank you.
No, it's yours.
Okay, thank you very much. Thank you. Have a good day, everyone.
You too.
Thank you.
Okay, Attorney Marable.
Yes.
Accept ready.
A-Cup is ready. Let me read.
We're gonna do a dismissal for Slash, but as soon as we do a dismissal, it's all you. I'm just gonna take, what, 3 minutes?
Can I bring her in?
Yep.
Okay.
Thanks, guys.
47440.
Yes.
I'm sorry, what's your number?
5931.
You said it so fast, say it one more time.
85931.
I keep trying to catch it all morning, I can't catch it, thank you.
I try to enunciate.
Thank you, Judge.
Okay, we are on the record as the people of the state of Michigan. First, we have a sledge. 2355247, Mr. Sledge is charged with the following. Count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, assault with a dangerous weapon, felonious assault with an habitual offender statement of good notice. They sent for preliminary examination.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Nancy Kessler from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. T. Sledge, P number 8054.
Mr. Sledge, can you state your name for the record?
TVL Sledge.
Good morning.
Good morning.
All right, are parties ready to proceed today?
No, Your Honor, the people are not ready to proceed. There's been multiple attempts by both myself and the officer in charge who's to my left in the courtroom to contact the complaining witness. The complaining, but we have not been able to do so. The complaining witness is not here, and we does not, or perhaps does not even wish to prosecute. So we are therefore not. The complaining witness has failed to appear, so we cannot move forward.
Any further defense?
Judge, we make a motion to dismiss.
Dismissed without prejudice, as people are not ready to proceed due to the complaining witness failing to appear or wishing to prosecute. Right, we are on the record on the case. I have signed the order. Should be on.
Thank you, Your Honor.
You're welcome.
Thank you.
Okay.
I'll put it in this file.
Where was that?
Oh, no. Just give it back to you that one. Yeah. Are you all right?
not a bad me, I got a church that's there across the street still. I started here around eight. Grand Rapids, Preston. So I guess they'll be present there, I'm in the jury there. Today, no, she did, so they leave. But I gotta get back to Grand Rapids before I. So, you're not having a day like me. I'm so happy to see it.
Nope. You can tell it
I'm
now.
like, what?
All right, we're on the record as the people of the state of Michigan versus Kansas ACUP 2355219. This ACUP is charged with count 1 and count 2, assault with a dangerous weapon, felonious assault. In counts 3 and 4, weapons, felony firearm with a commission with a motor vehicle felony adult advisory. Today's case set for a preliminary examination appearances.
Good morning, Your Honor. Aaron Decker, PA 593, to the people.
Good morning to the honorable court, Carla Marable, number 62755.
Good morning to everyone. Are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Yes, the people will ask for the mutual sequestration for any and all witnesses except for the officer in charge, who is to my left.
Any objection?
No objection, Your Honor, and just for the record, there's nobody in the court, there's a blank courtroom.
Okay. Yeah, I was going to say the same thing. So with that, I'm ready for
Yes, Your Honor. The people call Veronica Sane.
Jackson. Okay. I'm ready. Okay. Raise your right hand. You swear to tell the truth and the whole truth. Yes. Have a seat right here, and you can hold the microphone in your lap if it's easier to switch. Are you ready, Mr. Decker?
Good morning. Please restate your name for the record.
Veronica Sane.
Okay, now let me take you back to the day of October 6, 2022. Do you remember that day?
Yes.
Okay, was that day that you were at Motor City Casino?
Your Honor, a projection leading calls for a yes or no answer. Leading.
I can rephrase.
It is preliminary, but it's still, it started off very leading.
Okay. Were you, do you remember where you went that day?
Yes.
Where did you go that day?
Motor City Casino.
Now, is that Motor City Casino, which is located at 2901 Grand River Avenue in Detroit, Michigan, the city of Detroit County, Wayne?
Yes.
Okay. So what were you doing there that day?
My daughter wanted to cheer me up. She took me to the casino.
I'm sorry.
She wanted to cheer me up because I had to go to the doctor earlier today,
Uh-huh.
and she took me to the casino.
Okay. And so who was that again?
My daughter.
Your daughter. Okay. So, anything unusual happened with the casino that day?
Yes.
Okay. So, let's just, so what happened?
We
Your Honor, objection, it calls for a narrative. It needs to be a question and answer. He's asking her to give a narrative.
Narrative didn't quite happen yet. I'm gonna allow her to answer the question, so if it's too long of an answer, then I will.
Okay. So, let me see here. So where were you when the unusual thing that you just mentioned, where were you when that happened?
Motor City Casino parking lot.
Okay. So what were you doing there?
We were driving into the parking structure.
Okay. So what happened?
Driving into the parking structure. The lady sitting there, she was in front of us.
She was in front of my daughter and I was behind my daughter.
Was she in a car or out of a car?
She was in a car.
Okay.
A blue car.
Can we quickly just say, because you keep referring to someone, so you recognize someone in the courtroom today?
Yes.
Okay, could you point them out and for the record say something that they're wearing?
She has a blue mask on. I guess that's gray with white top.
Okay, and let the record reflect that the witness has identified Ms. Candace Account. Okay, so now you're saying that the defendant was in a car?
Yes.
What happened after that?
She was in her car, my daughter was behind her driving into the parking structure, and I was behind my daughter. And when we went into the parking structure, the lady sitting there kept stopping. She was stopping, was extremely slow.
In her car?
Yes.
Okay, go ahead.
So as she was going up, she would stop again, so my daughter tried to go around her. So she swerved her car. When she swerved her car, I started going more, and people behind me started going, land on their phone. So she can go.
Okay.
So she ended up having words. My daughter was on the phone with me. She's like, what's wrong with her? She had words with my daughter.
Who's
the lady here?
Who had words?
The lady sitting here had words with my daughter.
Okay.
Because me and my daughter was on the phone. And we wanted her to go into the parking structure. So when my daughter tried to swerve around, when she finally able to get around, she swerved her car, and then we had words going back and forth. So my daughter proceeded to go up the ramp. So when she went up the ramp, I ended up turning around because I didn't want to go up to the higher floor.
When you say turning around, where are you turning around to?
We were still on the ramp, and I ended up turning around, going up to the next level, the lower level. My daughter went up to the higher level. She turned in on one side, so when she turned, the lady here.
Can I just say, when you say she, what do you mean?
The lady in here.
Okay, and she's still in her car at this point?
She's still in her car.
Okay.
She turned to the right, I ended up turning to the left. To go into a separate parking structure.
Okay.
When she turned into that parking structure, I ended up going around, and when the lady in here came out of one parking structure into the one that I was in, we came into like a T.
And you're still in your car at this
Still
point?
in my car.
So you're in a T, you and her are in a T, both in your car, then what happened?
She pulled the gun, and she kept saying, bitch, I'll handle you. She kept pointing the gun at me, and I'm like, what's going on?
Okay.
Why is she acting like
If I may ask, so who pulled the gun?
The lady's in here in the grass.
Okay, and then, so was she still in the car at this point?
She was still in the car.
Okay, so when you saw that, what did you do?
I left, I took off.
Okay, all right. So then anything happened after that?
When my daughter and I went into the casino, the lady in the grave, we were telling them, the security was this lady in the parking lot. So they was asking, who was it? And she ended up, the lady right in the grave ended up walking into the casino.
Okay.
So we turned and said, that's her right there. So the security rushed to her. And she started saying something totally different, they won't happen.
Okay.
So security asked her to leave. I said, no, I'm calling the police. Don't let her leave. I'm calling the police. So I called the police. And security ended up saying, you gotta leave. So they walked her downstairs. They called the police as well. When they called the police came in. Whatever they did, I don't know. I don't know.
Okay. Nothing further.
Thank you, Yana. Good morning, ma'am.
Good morning.
Okay, so what time of day?
It was during the day.
Okay, you don't remember what time?
I'm not exact.
Okay, so you and your daughter are both in two different cars,
Yeah.
okay? And one is in front of my client and one is behind my client.
I'm behind my daughter, yes.
Okay, so this is the question. I'm trying to get the arrangements of the car, okay, right? Are you and your daughter right behind each other, or is Miss A, with my client in the middle of it? What is it?
She was in the front, your client was in the front, my daughter was behind your client, and I was behind my daughter.
Okay, so you say that this all started because she was going extremely slow, right?
Yeah.
But you're in a parking structure, right?
Yeah.
And you'd have been in many parking structures, correct?
Several.
And a lot of times people go slow because they're looking for a parking spot, correct?
No.
Okay, this was the question. At the time that you said that she's slow, Are there parking spots there?
No, we haven't even made it up to the parking station.
Okay.
We're going up the ramp
So you're going up the ramp and she's going slow.
to the point where she kept stopping.
Okay,
Yeah.
she's going slow, correct? So you yourself don't know if she got emergency phone calls, she's on text or anything, she's just going slow, that's all you know, correct?
Exactly.
Okay. And that's kind of irritating to you, correct?
No.
Okay.
No.
So at some point you blow your horn, correct?
Yeah.
Okay. You blow your horn because she's in front of you, so she wouldn't blow her horn at you because she's in front of you, correct?
Right, and no one was in front of her.
Okay, so you blow your horn and you said you and your daughter on the phone. Is that when y'all begin to get on the phone?
We stayed on the phone because they had redirected us to where we could park what street to go on. The other exit was closed, the other entrance.
Okay, so you said they redirected you. So one of the entrances was closed, so it was kind of confusion that day with the parking, correct?
Yeah.
Okay, well, no, I want to hear what you said. You said that they had redirected you. Why had they?
They had the other, there was a lot of construction. They had the other area closed. So they told us we had to take Temple. That's the only way we could park, is going on Temple and going on the parking structure.
Okay. There's a lot of construction and you had to take Temple to get to the parking. Okay. So you say that my client is going slow and you begin to, blow your horn, right?
Yes.
When you say you all blew your horn, what do you mean?
Everybody that was trying to go up the ramp behind me and myself blew the horn.
Okay. You blow the horn once, you blow the horn twice, you blow the horn a lot?
I blew the horn once, and the other people were blowing their horn and laid on their horn.
Okay, so people laying on their horn.
Yeah.
Right? So it's fair to say that if you're having horns and stuff blown at you, that could make you irritated, right? It could be very stressful.
I've never been stressed over a horn.
Okay, so at this point, what do? You say you go around, correct?
I didn't go around, my daughter was in front of me, my daughter tried to go around.
Okay, so.
And she swerved her car, so she couldn't get around.
Okay, your daughter, but it's a 2-lane, correct?
No, not one of that ramp.
Okay. Let me ask you this, and please let me finish the question, okay? Is that ramp 2 lanes or 1 lane?
The way she positioned her car.
Is that ramp, this is the question, is that ramp 1 lane or 2 lanes? Because most parking structures, you have a lane you go up and you have a lane you come down. So answer,
It's 1 lane going up and 1 lane going down.
okay, so your daughter goes around her, correct?
On the right side, yes.
Okay, and then your daughter just goes on and park, correct? This is the question, your daughter goes around her, correct?
She couldn't because she swerved her car.
Okay, so what did your daughter do?
She sat there, what else was she gonna do?
Okay, so she sat there in the other lane?
She sat behind her, when she tried to go around, she couldn't because she swerved her car.
Okay,
So it's
so-
nothing else she could do.
So your daughter just stayed there?
Yeah,
Okay. And at some point, my client parked, she proceeds on, correct?
never parked, we still went up the ramp.
Okay, you still going up the ramp?
Yeah,
Okay, so you go up the ramp, correct?
we're trying to go up the ramp, and then she swerved her car again.
Okay. Now, when you say swerve, what is your definition of swerve? Are you, okay,
Swerve.
okay, okay. So, you're going up the ramp,
Yeah,
and at some point, y'all get to the parking area, correct?
I got to my parking area.
Okay. Now, when you get to the parking area, what happens then?
She came out, she came across, I was in one side, she was in the other side, she came across into the garage that I was in.
Okay, because the garages are connected, correct?
No,
Okay, the garages are not connected?
there's a one side over here, and then you come across, and then there's another side.
Okay, so she drove to the side that you was at?
Yes,
Okay, so she drove to the side because she's trying to park just like you, correct?
I'm assuming.
Okay, so y'all are both trying to park, and then what?
When we met When she came across, we met right here.
Okay, I can say right here
And
for the record.
we were, I'm sure.
So for the record,
This is me, this is the lady here coming across.
okay, we just have to clarify for the record, people make gestures, it's not put on paper.
Okay.
So it's the T, both parties agree that it's, she's gesturing like the T?
Yes.
Yes, Your Honor.
Okay. Yes.
Yes. So y'all are both in the parking structure. And you still haven't parked, correct?
No.
And I'm assuming, and if I'm wrong, correct me, you're looking for a parking space, correct?
Yeah.
So if you're looking for a parking space, she's probably looking for a parking space too. You're looking for a parking space.
I'm looking for a parking.
Okay. So was parking hard that day? Was there a lot of open parking spaces?
There was a lot of cars.
What you mean there's a lot of cars?
Looking for space.
So there's a lot of cars looking for spaces. So
About 5 cars in front of me.
So it's fair to say that it's more cars than it is spaces. Because everybody's looking for a space.
Some people could have been leaving, I don't know.
Okay, so there's a lot of cars, but you yourself couldn't find a space.
Right in the area, no.
Okay, so you have to let me finish, ma'am, and not cut me off because she's taking a record. You yourself couldn't find a space right away.
Right.
Okay. So you then see my client again, correct?
Yes.
Okay. And you say that y'all are at a T,
Yeah.
correct? So with a T, someone's going north and south and someone's going east and west. Do you agree with that?
Yeah.
Okay. Who's going east and west and who's going north and south?
I don't know the northwest, east, south, none of that. But I know I was going, looking for a spot. She came across.
Okay, so the way your hand is, and with the prosecution, you're going east to west, and she's going north to south, correct?
If it's northwest, I don't know.
Okay, so you would have to drive in front of her. She's coming up, and you're driving across from her, correct? When you look at your hand, show the judge your hands and how you're doing it.
We were on the same floor. She came across the parking structure. I was in that parking structure. So when she came across, we met.
Okay, so one is going east and west, and one's going north south.
They were at a standstill.
Perpendicular.
Yeah.
Yeah, okay. So now at this point, right, you're not upset or anything, right?
No.
Okay, and you have your windows up?
My window was cracked.
When you say your window was cracked, what do you mean cracked?
I had it halfway full. I bet went down.
Okay, got music on?
No.
No music on?
No, wait, for the record, you said that much down. Once again, I need to know in the court.
I'm sorry.
You said that much down, how many inches were the road?
Probably 5 inches.
Okay. So, are you still on the phone with your daughter?
Yes.
Okay, so you and your daughter are on, you're trying to find a parking space. You and your daughter are probably coordinating your day. I'm trying to find a parking space, meet me here, this and that.
Yeah, I did say that to my daughter. I could come down to the floor that I'm on.
Okay, so you and your daughter kind of coordinate your day out. You're on the phone with her.
Yeah.
Okay. And you say at that time, what happened?
This lady here pulled a gun and she was yelling, saying, bitch, I'ma handle you.
Okay, so.
Doing a gun like this.
So the cars are how far apart from each other?
You're right here. She could have hit me.
Okay, so this is the thing. The cars is hard because they're cars, correct?
Yeah.
So it's not like you being close to the prosecutor. She's in a car, correct?
She's in a blue car. I'm in.
So the cars are what, 5 feet away as far as I am to you?
No.
Okay. So 2 feet away?
Almost touching.
Okay, the cars are almost touching.
Yeah.
But you're still in cars.
Yeah.
And cars, you agree with me, they have windshields, they have, you're not face to face with a person, correct?
You can see my face, I can see her face.
Right, but you're not face to face in the sense that you are, like, I'm face to face with you because you're in a car, correct?
Correct.
Okay. So, if this package, you're on the, of course, you're the driver. And from your driver's side to her driver's side is how many feet? From your driver's side to her driver's side is at least 10 to 15 feet, correct?
Maybe 7.
Okay, because you agree with me that you was driver, correct? And she's the driver, right?
Yes.
And y'all have the cars in between, correct?
No.
Your car, she's not out the car, right? You're not out the car, correct?
Correct.
So you're in your car, so your car is there, her car is there. The cars are between you and her being physically being in front of each other, correct?
Right.
Okay, because you're in the car and you say it's 7 to 10 feet from driver to driver.
7.
Okay. Now, you have to look over, correct? Perpendicular, you have to look over, correct?
Yes.
And the closest side would have been in this package. Excuse me for, I have trouble with this word. She's closer to your passenger side than your driver's side, correct?
Yes.
Okay. And your passenger side window is up, correct?
No.
Okay. You said that your driver's side window was a little bit down. Your passenger side window down?
I never said that. I said my window was down.
Okay, which one?
The passenger.
The passenger side window. Okay. Now, you say you hear from 7 feet away her saying, what?
Bitch, I'm a hazard you.
Okay. Now, how are you sure that those were the words that she said? Because you're 7 feet away, correct?
Because she was
Answer, listen. You're 7 feet away, correct?
Correct.
Okay. You're in your car, correct?
Correct.
And you yourself say that your window's not all the way down, correct?
Correct.
And there's construction going on, correct?
Not in the garage.
Okay, but the garage is not a very quiet place, correct? Because you yourself said that there's a lot of cars there and a lot of people looking for spaces, correct?
5 cars.
Okay. So you say you heard this, correct?
Yes, I did.
Okay. And you see something?
Yes.
Okay. Now, do you wear glasses?
No.
You have 20/20 vision?
My vision is good.
Do you have 20/20 vision?
Yes, I do.
Okay. You don't wear contacts or anything?
No.
Okay. So you see something in her hand?
Yes.
Okay. Could it have been a cell phone?
No.
Okay. Why not?
Because I saw a gun.
You saw a gun. You saw something black.
I saw a gun.
Listen. So describe it.
It was a handgun.
So if it's a handgun, describe it.
It was a black
silver?
pistol.
Was it blue? Did it have a pink handle or what?
No.
You just said handgun, you describe it. Because you are in your car, 7 feet away, and you have to look, your word, perpendicular. So there's handguns can be a variety of things. You're just saying it's a gun. And you agree with me that you never made a description, you just said handgun, correct?
A black gun.
Okay. Now, at that point, it's just put up in the air?
She was pointed at me. And when she was pointed at me, she was going like this, yelling, saying, bitch, I'm a hazard you.
Okay, now,
For the record, when it's pointing one finger, one thumb directly towards the prosecutor. Okay.
now there's a difference between, body moves. You agree with that? Okay, so if I have something, if I'm doing something like this, is that pointing at you?
No.
Okay. At that point, what happens?
I drove away and I was telling my daughter, she's like, Mom, what happened? I told her what happened. I drove away. I said, come down. I said, I'm going to get reported. So So my daughter came down, we found a spot close to each other, and we went in and reported to security.
Okay, now, your daughter wasn't there when all of this happened?
We were on the phone.
No, your daughter physically was not there.
No,
Okay, now, her car at some point had interaction with my client, correct?
I'm sorry, can you repeat that?
Her car at some point had interaction with my client.
They both had interaction.
Okay. Now, when your daughter tried to go around, didn't your daughter call my client a bitch?
No, she didn't.
Okay, what made you think she didn't?
Not at that time. Not at that time.
So when she did call her a bitch?
When she said, my daughter started yelling. She was like, Mom, this bitch just pulled a gun on me. She just pulled a gun on me. And my daughter stayed off and went up on the top ramp. And when your client ended up turning into one car construction, I told my daughter, don't go to the way she went. Come the way I went. I said, come to the right.
So your daughter basically followed her car?
No, she did not. No.
Okay, no more questions.
Quickly, so so you said that she pointed a gun at you?
Yes.
Did she point a gun at anybody else?
My daughter.
Okay. And you saw her pointing the gun at your daughter?
No, I heard my daughter say, Mom, this bitch just put a gun on me.
Yada, so I asked that be stricken from the record, because if she didn't see it, she has no firsthand knowledge of it.
That's fine, Your Honor.
Testified that on the cross.
Yeah.
Okay, thank you.
Thank you. Nothing further, Your Honor.
You're on.
Go back there. I'm sorry, let me go back in.
Just on, you in the room? Yeah. Or, Mr. Deputy, is she in the hallway or she?
She can sit in the hallway. I'm about to call her. Yeah.
Before you call her, I just need to make sure the court's not about to close it. So,
Fair enough.
I'm gonna die. Okay, there's no problem. I'll put it. Actually, here.
You ran the shit out of here. Yeah, painting, right? Yeah. Hello, this is Attorney Miracle. I've been here. Just on Zoom. The judge said about to close the court.
No, she didn't say that yet.
She said take us, that they may close the court.
She's following up.
To see if they're gonna close the
Yes,
court.
ma'am. Mhm.
That's for you.
What's that?
We're good for what?
Until 12 o'clock, to make a decision.
Okay.
I'm ready.
The people call, Shayna Saint Garcia.
Okay.
Go to the court reporter first and then stop by. Right here, ma'am, to the court reporter. Mask up and I'm gonna swear you in first. And then you sit down. You swear to tell the truth, the whole truth, and nothing but the truth. And have a seat. And if you wanna hold the microphone, you can. Just make sure you speak up, okay? Okay. Whenever you're ready, Mr. Deputy.
Good morning, please restate your name for the record.
Shayna Saint Garcia.
Okay, now I'm gonna take you back to the day of October 6, 2022. Do you remember that day?
Yes.
Okay, did you go anywhere that day special?
To Motor City.
To Motor City?
Yes.
Could you be more specific?
Motor City is a casino in Detroit.
Okay, so is that at 2901 Grand River Avenue in the city of Detroit and County of Wayne?
Yeah, no, yeah.
Okay. So is there anything that happened that day that brings you to court?
Yes, so, it was a lot of traffic this day, like they was doing a lot of construction.
Okay.
And,
If I may, where was this construction?
I'm not sure what street that is, but, you know how they do valet?
Yeah.
So it's that street right there, the officers, they usually park their cars on that one side street, so we were coming like towards Grand River, from Grand River.
Okay. So were you in your car that day?
Yes,
Were you alone?
yes,
Okay, was there anybody that you were going with?
my mom, she was in her car,
She was in a different car?
yes, behind me,
Okay, when you, so I assume that you went into the parking garage?
yes.
Okay, so you went into the parking garage and then what happened?
So on our way, and before we could even get inside the parking garage, there was a blue Fusion that was in front of us. And, there's so much traffic that was behind me and my mom, you know, everybody trying to get to where they need to go. And as we turned in, making a right that I know of inside the parking garage, everybody just started blowing their horn. I'm sure I probably done blew my horn once or twice just to, you know, like, if they fall asleep, like, what, you know, what's
Okay.
going on,
So-
or whatever.
So there was a lot of cars ahead of you?
Yes.
Okay.
No, it was behind me, so it was only one car in front of me, which was a blue Fusion.
Okay.
And then the rest of the cars, it was like a whole line behind us, me and my mom.
Okay. So after that, what happened?
So after so as we going into the parking lot, we make it right before we even get to the first row. The lady, she just got, I see her fussing in her car, which is inside confusion.
Now, when you say the lady, is there somebody in this courtroom that you recognize?
Yeah.
Okay, could you maybe tell me something they're wearing and point them out?
Gray or black and white suit and a white shirt.
Okay, let the record reflect that the defendant had, the witness has identified the defendant as Candace Aycock. Okay, when you say the lady, in there.
So the lady in, her,
Wait, let Mr. I'm sorry. Oh, so you have to make sure you let the lawyers ask the question.
okay.
Thank you. Okay, so you said that you saw the lady, what did you see?
She was fussing, mad, she was real angry.
Could you be more specific on fussing? Fussing?
Yana, it calls for speculation. She's speculating on somebody else in another car, or what she's seeing. She's speculating, it calls for speculation. Angry, mad. She doesn't have first-hand knowledge of that, it calls for speculation.
I did ask for a clarification and she's simply saying what she saw, and I asked her what she meant by fussing.
How about she can say what she's observing and believes?
Okay, what did you, I'm sorry.
Yeah, the only reason why I seen all that is because she was in front of us, we really couldn't even go.
Question, one second. The question was, what is your definition of fussing?
Fussy, like angry at the people behind her.
Yana, that calls for speculation.
I would agree.
Okay.
And I'll ask for that to be removed from the record.
Okay.
Okay, so then after you saw that, what did you do?
So I ended up finally when it was running to the right side of me, when I was about to go to the first row, which is upstairs, the second floor. And as I see her waving a gun at me, I didn't even want to.
Can we go back? So you saw, what'd you say you saw?
A gun.
Okay, who had a gun?
The lady didn't find it.
Okay, so where did you see it?
She grabbed it from like, I don't know if it was on the floor in the passenger seat, but as I'm on her side, her right side, I was about to turn right in the parking lot. The part, she's about to turn left, as soon as I see her grab her gun and aim it and telling me, you know, that she got something from me or whatever, that's when I continue going straight.
Okay, so when you say she aimed it, where was it aimed?
Towards me, at me.
So it was aimed at you? Okay.
Face, yeah.
Okay, so when you saw a gun aimed at you, then what did you do?
I went straight instead of turning.
Okay.
She was turning on the same row.
Then after that, what happened?
So I ended up going to, if I'm not mistaken, it was the third floor. I ended up turning around because my mom called me like, you know, basically to come back down that she was gonna park on that floor. Soon as I came back down, somehow, as soon as I like turned, I seen the lady make she made a left, a right. And my mom was right there. And she just started aiming the gun at my mom, telling her, you know, what she was gonna do. So I told mom, just come on, let's tell the security, like, because I have a son, you know, I have a 2-year-old son, I mean, my life. You know, you could be going day.
Okay, so then so after that, what did you do?
We went inside, Motor City Casino. As soon as we got to the front where they checked the ID, we told exactly what had happened, told them that she may be coming in here. You know, we unsure if she armed, you know, why she coming in. When we didn't see her, we pointed her out, and that's when the security told her that she had to leave, but instead they called the police, and so did we. They took us inside the back where the security, you know, security.
So then, nothing further, thank you.
Good morning.
Hi, how are you?
Okay, so you and your mom are going into a parking structure, correct?
Yes.
Okay, now how are the cars positioned?
So we are like in a single line before we got turned inside the parking lot. And you know how when you first go up the ramp, it's a entrance that you can go either or. Some people may turn left, some people may turn right.
So the cars, which car is first?
The blue Fusion. Is
Okay, And then are you directly behind the blue fusion or you a couple? And then where's your mom?
Behind me, which is the third car.
Okay, so you're excited because you're trying to get up into the casino, correct? And you're in a hurry, correct?
No, I wasn't in a hurry.
You wasn't in a hurry? Okay.
So many cars behind.
And there was a lot of cars behind you? Because there was a lot of construction going on?
Yeah.
So, the blue fusion, it stops?
It was, so we was at a stop sign, that's how I like, literally once I know.
So this is the question. The blue, you're behind the blue fusion. Are you blowing the horn at the blue fusion?
I didn't blow the horn at first, everybody else was blowing.
Okay, did you eventually blow the horn?
Yeah.
Okay.
I thought something was wrong.
You thought something was wrong? How long was the blue fusion there? Was it hours, seconds, minutes, what?
It was about a few seconds, then
Okay.
stop.
So, the blue fusion is, stale for a few seconds and you begin to blow your horn.
So in the beginning, I didn't blow my horn, the other cars did.
The other cars did.
You know, I didn't really pay no attention to it because I'm like, okay, we almost.
This is the question. So the car is basically not moving, right? And to be truthful, the car not moving irritated you, correct?
No, it didn't.
Okay, but you wanted to move.
I was just trying to figure out what was going on. I never seen a car go that slow, you know, especially when there's no other cars.
Okay, so you never saw a car go that slow. So you're trying to figure out what's going on.
Yeah.
And you're also trying to get into the parking lot.
Yeah.
Okay. So what do you do?
So I patiently wait, and then afterwards, once.
When you say you patiently wait, you said that the car was only stalled for a couple of seconds. Correct?
Like, I necessarily didn't start anything.
Okay, this is the question, ma'am. Didn't you say that the car was only stalled for a few seconds?
Yes.
Okay, so a few seconds is not a long time, correct?
Correct.
Okay, so for the few seconds that the car is stalled, what do you do?
I blew the horn.
Okay, and then what do you do?
Afterwards, when I seen the lady hands and going up and busting, because she had her window down a little bit, I pulled to the side, on the right side, about to turn the side of the parking lot.
Okay,
The other car.
so you go around her, correct?
When I had space.
Okay, so, and there's no problem with you going around her, correct?
No.
Okay, so you go around her, and then what do you do?
That's when I see the gun.
Okay, when you go around her?
When I was like, of course, you're not gonna speed around a person, so I went around slowly.
Okay.
That's what made.
So
me
you go
speed.
around her slowly, right? Because you're still driving. Do you ever make a stop?
Yeah. To make sure no cars, yeah, and I ended up turning, I seen her on my left side with the gun.
Okay, so when you allegedly see the gun, you just see it, correct? It's not pointed at you, okay? Okay, now listen. Listen.
One second, Ms. Garcia, can you make sure for the record you say yes or no? It's hard for it to document. Okay.
So you go around her, right? And you say you see a gun, right? You're not stopped or anything, correct?
No.
So you're not engaging with her, you just see a gun, correct?
Yes.
Okay, if you just see it, that means it's not pointed at you or anything like that, correct?
Okay, so I don't wanna.
This is it's a yes or no question. When you go around her, you're going around her, correct?
Yes.
You don't stop, correct?
At first, I'm slowing down, then I make a stop. That's how I end up seeing a gun.
Okay, you make a stop, are the cars next to each other when you make a stop? How okay, so the cars, you go around her, because it's only 2 lanes, correct?
Correct.
You go around her and you stop.
Yes.
Okay, now this is the thing. What was the purpose of you stopping? Because you're already, if you are going around her, you're in the ongoing traffic lane, correct?
Correct.
You stopped in ongoing traffic lane? Because that's what's dangerous, correct?
Correct, but I also was turning right too.
You was trying to what? I also was turning right on the same level she was turning on, I was turning on, but.
Okay, so to turn right, you have to be in front of her, correct?
Correct.
So this is the question. You go around her, you stop in the lane that oncoming traffic is in.
It was no ongoing traffic.
But you stopped at that lane, correct?
It was the same.
This is the question.
Stop or not?
Do you stop? Yes or no?
I stopped.
So you stop in the dangerous lane where oncoming traffic is in, and then you get in front of her to turn, correct?
Right.
You stopped in that lane on ongoing traffic to engage in conversation with your client, didn't you?
Not necessarily.
Not necessarily. Okay, what you mean not necessarily?
Because I'm turning right on the same level. But
Okay, you're turning right on the same level, but to turn right, you can't turn right from that lane, incoming traffic lane, correct? Correct?
Correct.
So you have to get in front of her to turn right, correct?
No.
Okay, you can turn right from where?
The Motor City parking lot, when you first go in, it's two ways. So she was on the left, towards the left side. By the poles in the middle. It was more than enough space on my right side. To get away from her, yes, I was.
Okay, but it's only two lanes, correct?
It's two lanes, correct?
It's two lanes. So if it's two lanes and you're gonna turn right, you gotta get in front of her to turn right. And correct?
No.
Okay, but you stop in the lane of ongoing traffic, incoming traffic, where you could have been head-on crash. Okay, you say no. So you go around her, and how do you see the number?
Stop.
You stopped.
I told you I. Yeah.
Okay, the windows down?
Yeah.
Okay, you cussing at her? You say anything?
After I pulled up, yeah, I said, fuck you.
Okay, so the windows down, and you say, fuck you, correct?
Correct.
You put up any hand signs?
No.
Okay, now, if I'm driving and I say, fuck you, is that, how would, somebody, at that point, she hadn't said nothing to you, right?
She did.
Okay.
Because she got from the
So when you're on the side, this begins when you're on the side of the car, correct?
Yeah.
Okay. And you agree to you're on the side of the car and you're not in the proper lane, correct?
The proper, can I say?
No, okay, it's only two lanes. We can go back,
First of all, one second. Can you clarify the question? I think.
Okay.
You to answer.
Okay. Let me just go back through it. It's getting to the garage is two lanes, correct? There's a lane going up, a lane coming down, right? To go around my client, you have to get into the lane coming down, correct? You, at the time that you engage in my client, you're in the lane coming down, because it's only two lanes, correct?
No.
Okay, tell me.
So basically, in the middle of one side of Motor City parking lot is a pole. There's a few poles in the middle, so everyone that's coming down, they stay on one side. Everybody that's going up, they stay on one side. She was closer to the pole, so it gave me more room on the right side towards the wall to make that right. Just to get away from her, of course, that's what I tried to do.
So at some point, but even though you say you're trying to get away from her, you stop where her car, where you can engage with her, correct? Okay, now, listen to this. You stop and you engage with her because you go around and you stop, correct? At that point, she had always been in front of you, correct?
Right.
And since she had always been in front of you, she hadn't said anything to you, correct?
I just seen hand language.
Okay, so this is the question. Before you park your car next to hers, it's a yes or no question. She had been in front of you, correct?
Correct.
She hadn't said anything to you, correct?
No.
No verbal communication. She hadn't called you a bitch. She hadn't said fuck you and none of that, correct?
Not correct.
Oh,
She said
okay.
not correct.
Did you say not correct? Not correct.
She's in front of you, correct?
She's in front of me, correct.
So did she open the door and yell out, bitch?
No, she did not. The second time when I went on the.
No, I'm talking about the very first time, step by step. We're gonna do step by step, right? You're behind her, correct?
Yeah.
Okay. When you're behind her and before you move around, you hadn't had no conversation with her, correct?
Correct.
Okay, because you couldn't have conversation with her because you're in your car and she's in your car. Y'all are two different cars. And you looking at her from since you're in the back, you're looking at the back of her, correct?
Correct.
And you agree with me, she didn't get out of her car and yell at you or anything like that, correct?
Correct.
But you are a little irritated because she's holding up traffic, correct?
No.
Okay, but at some point you decide to go around, correct?
Correct.
And at the time that you go around, you decide to position your car right there and engage with her. Okay, why didn't you, okay, so you just couldn't go around and just keep going?
There's so much traffic, you don't wanna get hit.
Okay. So if it was so much traffic and you didn't want to get hit, why didn't you just stay behind her?
There's just too much confusion in traffic.
Okay, because then when you agree with me that when you were behind her, she never yelled at you, she never cussed at you, she never got out her car or anything, correct?
Right.
The confusion didn't start until you got on the side of the car with her, correct?
Correct.
Okay, so you get on the side of her, and that's when the confusion started. You say fuck. You said on the record, excuse my language. I want the record to be clear, so I'm gonna say some cuss words I normally would not say on the record. But you do say fuck her when you're on the side of her, correct?
Yes, after I see them.
Okay, now. When you're on the side of her and you're stopped, what was the purpose of if you see the gun? Somebody has shown a gun and you say, fuck you. Okay. Isn't it more, you're on the side of her, correct?
Yes.
And when you're on the side of her, do you roll down your windows, ask, well, why are you holding up traffic or any of that?
No, my window was already cracked.
Okay. But you're saying that after after you see a gun, you begin to verbally engage them?
That was the only thing I said.
Okay.
While I was
This is a yes or no question. After seeing a gun, you verbally engage them.
Right.
You're not saying that you verbally engaged them before you saw the gun.
I didn't say anything before.
Okay. And then you go around her and you do what?
As soon as I see the gun, I kept going straight.
Okay, so once you see the gun, you go straight.
Yeah.
But what you go straight after you say fuck you.
Yes, I believe that was
Correct.
Okay. And then what happened?
So that's when my mom called and told me that she was on the second floor to come down, and I asked if she sure that she wants to, park on that same, floor as the lady.
So you're on the phone with your mom, right? Okay.
Which I was on the top floor higher than them. And I also came back down, as she said that she was.
So let's back up. So you and your mother are together. So y'all talking about where y'all gonna park it, right?
Right.
And you're ahead of my client, right?
Yes.
So you call your mother and tell your mother where you parked at, correct?
Yes.
Okay. Did you call your mother and tell her that you had told this young lady, fuck you, and all the incident?
That was the only thing I said.
Okay, so you did tell your mother that?
No, I didn't.
Okay, you're on the phone with your mom, correct?
Right.
And what did you tell your mother that you had an incident?
She saw the whole thing. She was behind us.
Okay, so your mother is saying she saw it?
Yes, she saw her arguing and pulling up a gun at me. what
Okay,
made me-
so but you said that there wasn't no argument. Now, hold on, let's go back. You said that you went on the side, she pulled the gun, and you said, fuck you. But now you're saying there's an argument.
If you wanna.
Okay, okay, are you saying something different now?
So basically, you just trying to make it seem like I'm switching it over. And I'm not.
Okay, I want to.
Arguing, she tried to argue me down, and
Okay.
all I said was one thing, and that's when as soon as
So.
I see the gun, I said that and I pulled it off.
Okay, so let's go back. Previously, you said that you pulled on the side.
Correct.
And that you, okay, so you pulled on the side and y'all began to argue, correct?
I said one thing, yeah.
Okay, and this is before you see the gun.
This is after I see the gun.
Okay, you pull on the side and you say one thing. But now you said argue. So y'all are arguing back and forth, correctly? You know all of this is on it. Y'all arguing back and forth, correct?
She argued me down, yeah.
Okay. This is the question. Y'all are arguing back and forth, correct?
Now that you made it clear, no, we was not. She argued me down.
Okay, so you're saying she's arguing with you and you're not arguing with her?
I said one thing.
Okay. But you sit there and listen to it. So because this is the thing, so let's go.
Answer the question. Did you sit there and listen to what the defendant was saying?
No, when I think it, who wouldn't be scared when they see a gun?
Okay, you keep saying that, but you wasn't scared to say after you saw the gun, fuck you, right? You wasn't scared to say that, correct?
Correct.
Okay, so let's go back through it. You pull on the side and now you're saying y'all arguing. What do you consider arguing?
I consider an argument is when two people are arguing, but I also feel like.
Are y'all going back and forth with each other?
Arguing a person down than just one person arguing a person down.
Okay,
So if it was
but you-
communication, I apologize about that.
So I think the testimony scripture just, when she said, she said one thing was fuck.
Okay, but you said arguing, so you you're on the side of her, and y'all are going back and forth with each other, correct?
Correct.
Okay, you're going back and forth with each other, and at some point, you say, fuck it, and you move on.
Yeah.
Okay, no more questions of this witness.
Redirect.
No redirect.
You all said you can step down, have a seat.
Okay.
No, Your Honor.
No witnesses.
All right. Whenever you're ready.
Equal motion for buying over to circuit court. We reserve time for argument. Question of fact has been established for the trial.
Okay.
Attorney Murphy.
Okay, preliminary exams are probable cause hearings. They're the lowest standard in the criminal justice system. And you have to prove that a crime happened and there is probable cause that a crime happened, right? One of the things in this particular case is, I think that the scenario is unbelievable, right? Okay, so they're mad at my client because she's going so slow in the garage. You don't know if she's on the phone, she's having some medical conditions, right? But it's for the judge's credibility. The young lady testified that, oh, I pulled on the side of her, but I didn't say anything, and this and that. They are the aggressors in this particular case. My client in this particular case has a valid CPL and was scared for her life or was scared of attack. So she probably did show them the gun, but she was scared. But their testimony is uncredible. My client, I think when you look at credibility, she's going to the spa. She's finishing her residency. She's in the middle of her last rotation. She's going to the spa. She's on the phone trying to figure out directions of where to park at because that. these ladies come, it's two of them, right? They ganged up on her. I believe in this case, if they have not met their burden, especially with felony firearm because she has a valid CBL. Thank you.
Your Honor, the people motion for bind over on count 1 for assault with a dangerous weapon, count 2, assault with a dangerous weapon, and count 3, weapons, felony firearm, and also count 4. And yeah, count 4. If we heard the testimony today of the witnesses, both of them were in separate cars. Both of them said that the defendant did at some point a gun at both of them. First, she was showing a gun, and then she was pointing a gun, and both witnesses said that happened. There's some I disagree with the defense about the idea that there was that they were actually the aggressor in this case. It sounds as though that the daughter did not actually say anything until after the weapon was shown. So it seems to me like this is like when she reacted and when she said anything to the defendant, it was in response to being shown a gun, which is, obviously maybe somebody doesn't want to say anything when somebody sees a gun, but I don't really exactly find her reaction to seeing a gun or having a gun pointed at her to be exactly unreasonable. There's a question of fact that has been established by this process and it's ready for circuit court. So thank you.
Okay, I'm not going to recite the testimony all over again. We heard from Ms. Sane, Veronica Sane, and Ms. Shayna Sane Garcia. What I think this is a case of road rage, a little bit in the parking lot. Ms. Acuff was driving too slow for both complaining witnesses and everyone else behind them who blowing their horns and trying to get somewhere. Ms. Acuff not committing a crime at that time. I think everybody was getting irritated. With Ms. Veronica saying her testimony was a little more clear, but also matches up as far as the placement of the car. The defendant was first, then it was Ms. Shayna, then Ms. Veronica, then several cars behind them trying to get the parking spot. We didn't hear from Ms. Acuff because for some reason, she has the right to remain silent. But it seems to me that, people were irritating her while she was driving. Now, testimony is that the mom, Ms. Veronica, went to a different floor, but that when Ms. Acuff said to her, while she was in the vehicle, pointed a gun and said, "Bitch, I'll handle you," maybe once or twice. And then Ms. Veronica saying when to report that, and Ms. Shayna saying also testified to Ms. Acuff pointing a gun at her and saying something to the face. She got something for her, and Ms. Sane Garcia replying back, "Fuck you." Both saw Ms. Acuff with a gun aimed at them. He described it as a handgun. And although I do think that both complaining witnesses were agitating Ms. Acuff, based off testimony, I don't think that it arises to justification for pointing a gun at them and saying, I got something for you, I'm handling it. So
Wouldn't it be the misdemeanor brandishing? What happens to the witnesses, the facts that are recited would be brandishing?
So I'm going to read assault with dangerous weapon elements. So first, the people have to prove that the defendant either attempted to commit a battery on the complaining witnesses or did an act that would cause a reasonable person to fear or apprehend an immediate battery. I think at the standard, the people have proven that Ms. Acuff did an act that would cause a reasonable person to fear or apprehend an immediate battery. Second, that the defendant intended to either injure or make complaining witnesses reasonably fear. So I would say the second part, Ms. Acuff what made the complaining witnesses reasonably fear an immediate battery with the point of the gun. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought
she had the ability. With the testimony of holding a gun and pointing it, she had the ability to commit battery. And fourth, that the defendant committed the assault with a dangerous weapon, and that weapon being the handgun as described by both defendants. So I do think that the people met the FA assault with dangerous weapon elements here. That's a probable cause thing. So I'm gonna have Ms. Akins round over on all 4 counts with an arraignment on information of March 8th at 9:00 a.m. at Framework College. Justice. Are you waivers? We're gonna do the Robinson. Yeah, I just want to see if any dismissals I can get out the way.
Okay, they're calling me about my jury across the street.
Okay. I'm not trying to take short down, but I'm gonna say as long as we can get the ball here. Okay, so it will be, I'll be. Okay.
Are they gonna shut the court down?
It's good.
But it's, we call it.
Okay.
I don't know about that.
They calling me.
I'm walking across the street.
Okay, we have a waiver. We're going to ready to put on the record, so then you guys will be next.
All right, be there in 5.
Okay. Here on the record is the people of the state of Michigan versus Joshua Burrows, case number 2355316. Mr. Burrows is charged with count 1, stolen property, receiving and concealing motor vehicle, count 2, motor vehicle unlawful driving away, count 3, larceny in the building, the habitual offender second offense notice, as well as case number 2355324, which Mr. Burrows is charged with count 1, stolen property, receiving and concealing motor vehicle, count 2, motor vehicle unlawful driving away, count 3, larceny in a building with the habitual offender second offense notice, both exams set for examination today. Appearances.
Good morning, Your Honor. Eric Decker, PA 59313, or good afternoon.
Veronica Walrad, PA 5665 with the DS on behalf of Mr. Joshua.
Mr. Burrows, can you state your name loud and clear for the record?
Joshua Michael Allen Burrows.
Thank you, good afternoon. Okay, is it correct that your client is wishing to waive both exams?
Yes.
Okay. Mr. Burrows, I'm gonna ask you a series of questions, okay? Make sure you speak up for the court first, okay? Is it your wish to waive your preliminary exam today?
Yes, ma'am.
Okay. Do you understand you have a right to preliminary exam?
Yes, ma'am.
You understand that if you were to demand your exam today, the prosecutor would have to show the lower standard, probable cause standard, that those charges that I read off were committed in the city of Detroit and that you committed those crimes, probably committed those crimes.
Yes, ma'am.
And by waiving your exam, you understand that the prosecutor does not have to do that today?
Yes, ma'am.
And knowing that information, you still wish to report and waive your exam?
Yes, ma'am.
Couple more questions. Did anyone force you or threaten you to waive your exam?
No.
Okay. Did anyone promise you anything?
No, ma'am.
Okay, so I find your waivers to be freely understanding they are voluntarily given. So, also, Mr. Decker, prior to going to the record, I understand that you didn't have any objections, is that correct?
That's correct, Your Honor. There was no objection.
Okay, so with that, I will have you bound over Mr. Burrows on both cases. Since you are in custody, it'll be 1 week from today, March 1st at 9:00 a.m. Frank Murphy Hall. Okay?
Your Honor, if I could address bond in this case, Mr. Burrows has been in custody. He does have a small cash bond of $500 in one of these cases. Our social worker from our office, Mr. Mike Davidson, has met with him and been working with him to create a treatment track for substance use disorder. There is currently a spot available for Mr. Burrows at Team Jefferson, where he would be able to move and begin participating in what treatment and programming they provide, which is designed to, I think, get the ball rolling with treatment and also provide some support and housing so that he would have somewhere known to go. From there, the plan Mr. Burrows is helping with is that he would go to Dawn Farm. So we have multiple stages of treatment planned out and available for Mr. Burrows, Team Jefferson immediately, and Dawn Farm in the future. For that reason, I'm requesting that the cash bond be amended to a PR bond, and also that the court consider removing the tether requirement on the existing personal bond, simply because of the delay that it is likely to cause in accessing the treatment, as the jail does take several days to attach tethers in many cases.
Question, so if there's no tether, my concern is whether or not he can go to and from the treatment center. Is it one of those type of locations, or does he get in?
It's at the treatment center. So Team Jefferson provides the treatment, is my understanding.
But can he even come and go throughout the day?
Your Honor, if the tether would be required in order for him to be allowed to come and go, I think that the tether would be okay.
No, what I'm asking is that facility, one of those places where it's inpatient, where you don't have access to go and do regular duties, say grocery shopping or do or daily duties, or is some place that he is required to stay most of the time so that he can get treatment?
They provide housing, but you are allowed to go about some elements of your regular day.
Okay, that's what I'm trying.
Apologies, I misunderstood.
Oh, that's fine. Mr. Decker?
We would like to preserve the tether, Your Honor, but the seeking treatment seems to people to be a good thing. As far as the tether, it seems to me like that would be the best way forward.
So I do want a tether, but I understand that the beds they come and go, and you have to wait a very long time. So I will
Maybe
change.
conditional on the receiving treatment.
I'm sorry, say it again.
Wouldn't we want to make it conditional on make sure that he's actually receiving treatment and that he's actually going to be in the facility?
Yes, that's been confirmed that he's going to be in the facility.
Oh, okay.
Yeah,
Then, yeah.
correct?
Yes.
Okay.
Okay. And I don't have the bond information. Are both cases the same as far as bond?
No, Your Honor, one has a cash bond of 500, and the other has a personal tether.
So both, I'll put it at a personal $1,000. I don't want him to. Okay, this is what I mean. Mr. Burrows, I'm going to allow you to be released so that you can get treatment. Okay. Are you employed?
Time.
Not a time. So I'm going to allow you to get treatment. And what's the name of the location? Jefferson.
Team Jefferson.
Team Jefferson. And while you are there, Mr. Burrows, you are not to leave that location unless it's for medical reasons, if you have to go to the hospital or treatment. Other than that, you have to remain there to receive treatment, okay?
Yes, ma'am.
And then once you are transferred to another location, you need to provide the information to your attorney to provide to the court.
Yes, ma'am.
Because the tether unit, I know it's taking them a week to put tethers on people right now. I'm not gonna put a tether on you so that you get your treatment, okay? And that means that I am trusting that you will treatment and do what you're supposed to do. If you violate bond, then you'll have to post $1,000, okay? Any questions about terms of bond?
No, Your Honor.
Anything else? Okay.
Your Honor, if that order is taken in case of treatment so that Team Jefferson can take him up and transport to the jail. Thank you.
Is it Team Jefferson House? I don't know.
Team
why.
Jefferson.
Thank you.
Yeah, Mike. All right.
I don't know.
I am ready. If we're holding, I do have to grab my file, so I do have to, if we're holding, I'm gonna grab my file.
I don't know how this supposed to do it.
Okay.
Thanks.
So what's going on with Dean Ware?
They hold.
They hold up. All right.
Wait a minute. Probably not.
Okay, we're on the record. This is Michigan versus Jordan and Manuel Davidson, who is defendant number 1, and Deontay Jackson, who is defendant number 2. This is case 22-61042. Defendants 1 and 2 are charged with count 1, assault with intent to murder, count 2, assault with intent to murder, count 3 and 4, assault with intent to do great bodily harm less than murder or by strangulation, count 5 and 6, assault with a dangerous weapon, felonious assault, count, defendant 1 is charged with counts 7 and 8, weapons, felony firearm, defendant 2 is charged with counts 9 and 10, weapons, felony firearm, defendant 1 is charged with count 11 and 12, weapons, felony firearm, defendant 2 is charged with counts 13 and 14, weapons, felony firearm, defendant 1 is charged with count 15 to 16, weapons, felony firearm, and defendant 2, 17 and 18, weapons, felony firearm. Today's day set for a preliminary examination appearances.
For your assessment, we have people, P67104. And good afternoon, Your Honor, Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Candy Jackson, who's also present in the courtroom. Mr. Jackson, can you please state your name for the record?
Jackson. Afternoon, Your Honor, Andrew Mogg, CQ number 69568. Mr. Davidson, State.
Julie Davidson.
Good morning or afternoon.
Yeah.
Okay, so I need to ask if there are any preliminary matters. I received a motion. Is there anything else other than the motion that preliminary we discussed?
Preliminarily, I guess it depends on what happens.
All right, so, Attorney Phelps, you received the motion.
I did,
Your
yes.
Honor. Okay.
And the items that were requested, people did turn out for yesterday.
Okay. All right, so did you make the motion?
Yes, Judge, I do, for the record. So, Your Honor, we were here back on February the 7th, for preliminary examination, which was, sure you recall, was ultimately adjourned, because of several outstanding discovery items, and we did discuss on the record at that time, you know, why there was delay in, bringing the issues to the attention of the prosecution. And so we adjourned it to today to give the prosecution an opportunity to provide the missing discovery. You did sign an order ordering the Wayne County Prosecutor's Office to make sure that the discovery was produced before today's date. Unfortunately, that didn't happen. On February 10th, I reached out to APA Nurse just to make sure that she received the order that you had signed and sent to both of us. She confirmed that she had and that she was working on it, and then I never heard anything back again until late last night. I did file this motion yesterday, as soon as I was able to get to it, rather late in the day. And then I did receive a response late last night from Ms. Necessian indicating that unfortunately she had been on emergency family leave, which I'm sorry that had to happen. However, you know, the order that you signed was to compel the government, the Wayne County Prosecutor's Office, to produce the necessary discovery to us. I did receive an evidence.com link late last night also that I was able to download this morning, not review. It had over 17 gigs of items in it, and so that has not been reviewed at this point. And Your Honor, I would stand by my motion at this point and ask for the case to be dismissed as the order was not complied with. Again, I'm sorry that this Narcissian was taken out of the office for some time. However, you know, this issue came up on February 7th, today's the 22nd. I don't know how long she was out for. But again, the order was for the Wayne County Prosecutor's Office. And I don't know what their procedure is in their office, but if I am out on emergency leave, which I also was last week with my partner in the hospital, I have to have somebody else stand in for me because people's lives are at stake with both of our jobs. And so, again, the burden here is on the prosecution to produce that, not Ms. Narcissian herself. And so, Your Honor, I'm asking for you to consider the written motion that I filed with the relevant legal standards, including your authority to dismiss a case for failure to comply with a court order under 6.201J, I believe, of the Michigan court rules. And there's also case law that supports your ability to do that, Your Honor. So again, the discovery was provided not in enough time for us to be prepared for today's hearing. And Mr. Davison, who is not my client, but he is incarcerated as a co-defendant on this case. And my client has been on tether since the beginning of January on this case, and though he's not incarcerated, the toddler does have a great impact on his life, let alone just the fact that these charges have been pending against him. Your Honor, so we're asking for the case to be dismissed.
Yes, Your Honor. Well, I will first state that the items requested by the defense were brought to people's attention the date of the last exam. So we did not have an opportunity prior to the last exam to even consider that there were items missing that the defense requested. Yes, I was taken out suddenly, and frankly, I was not tending to my work items because it was a true emergency. Upon receipt of the notice and motion by defense at 6:30, I sent that discovery link probably within the hour, if not hour and a half. So that would have been, if I received this motion at 6:30, I would have sent it at actually prior to 7 p.m. And I am aware of that because I had another, because I had an appointment at 7 p.m. And so I am asking that this court not dismiss this matter. The remedy is not dismissal, but an adjournment if the court so chooses. Discovery is an ongoing issue. The items have been tendered. There was no malice intended in the failure to turn over the item. All items that can be turned over, that can be found and have been found, have been turned over to defense.
Attorney Boxer, do you have anything to say on the motion? I know.
Only if you grant the adjournment, I ask it be attributed to the prosecution, noted on the record.
Your Honor, I would just briefly respond that malice is not a requirement for the dismissal remedy that is in court rules that within your power to dismiss this.
Neither is dismissal though for a failure to turn over the discovery time.
Okay, so because the discovery was provided, I am not going to dismiss based off of what it was provided. It was provided yesterday. AK necessity and had family emergencies. I am not insensitive to people having family issues. I believe counsel, there was some, Attorney Phelps, you had some issues with being out of the country, having an opportunity to review discovery last time. So discovery has been provided. Is there anything else that you do not have, or you have not even looked at?
I don't know, it's 17 days, I haven't had an opportunity.
Okay. My only concern is Mr. Davidson, who is in custody. That's
Yeah, and it is a concern, but he does have a second matter,
Right,
another capital case that's already in Frankfurt case, so.
So the question is, calendar wise, how would that case move along?
Anything could be happening, they're extremely.
Okay. Attorney Phelps, how much time do you need to, do you think you need to review?
I will say a number of those files are single photos.
They're all, I mean, look at and Your Honor, I mean, it's difficult. The rest of my week I have, it looks like 3 exams per day. So, unfortunately, I do work 40 hours, but. It looks like that's when I could be for an exam would be March 1st. I'm sure sometime I can.
Hopefully it's not scheduled.
Judge, I do want to address another matter that I emailed about. I believe that court was also with defense counsel believing two the witnesses with the court appointed attorney. I don't want to fail to place that on the record.
You go right ahead.
Okay, so it was brought to my attention
that defense believes that two of the witnesses would need an attorney. I do not believe that they would incriminate themselves in any manner. The people, as well as the police, have obtained statements from both witnesses. I have spoken to both witnesses in person at the last court hearing. There is no reason to believe that they would be incriminated in any crime themselves. So the people do not believe that there is a necessity to have attorneys appointed to them. I understand defense doesn't know.
Let's finish this, or this after, Mr. Davis and Jack, or Mr. Davis and Jack are not. Sure.
Are we thinking about the afternoon on the first? They've got a pretty full.
I have a 2 o'clock for the grand meeting. So I can do the afternoon.
Well, the second or the first works for that. So. Whatever you guys.
The second afternoon works for me.
All right.
That works for me. I do not have.
Thursday the second.
Okay. So we will adjourn this to your Thursday, March 2nd at 1:30.
Your Honor, if I could speak to bonds, before Mr. Jackson moves around. Or you go right there. Your Honor, as I've already stated in my motion to dismiss, Mr. Jackson has been on tether since the beginning of January. In this case, he hasn't had any violations. He has no prior criminal history, and there's nothing indicating that he's a danger to the community, or is he a flight risk. He's shown up for every court date. And again, he has 0 prior criminal history, and he, and the allegations here are really the allegations. And again, I'm not sure if you have the investigator's summary, but Mr. Jackson is not accused of being the shooter in any way. And so, Your Honor, I would ask for you to consider removing the tether. Again, the delays that have happened here are not attributed to Mr. Jackson, and it does affect this life.
How is it affecting what?
Your Honor, he is not able to work. I mean, just having it on his leg is affecting him, and he does cost money. How much did you spend on it?
I can't hear you guys speak up.
At least $200 so far for paying each month.
Well, and they bill more than that even too, so it is costly for him to keep it on.
And how is it permitted him to work?
So it's like,
Say that to speak up.
so I work with my father at a family business, DJ service, and we have different, events on different days. And sometimes I stay out late because of that. And I also have another job in security. I do also work for my church, so it's like I don't have time to do anything because of the tether.
Because of your restriction on the time, the tether?
Yes,
I can address that if you're working.
Your Honor, we did address that last time, Your Honor, but just the prejudice of having the tether on, have these public safety jobs.
You can wear pants for now, it's still cold outside. My concern is also the safety of the community. I haven't heard testimony yet, but based off of the charges, I'm not comfortable. So I'm trying to make things as convenient for him, which is not my obligation while he's wearing a tether. So I'm trying to figure out what time you need to have extended so that you can work and be employed.
So it's based off the customers, the time they book us.
So 24/7 you could be working?
Basically, like on the EJ schedule, like it's up to the customer what time frame they need us, or with the security job, it's up to the customer what time frame do I need us. And then church has several events as well on the week or on the weekend.
Okay.
And it's just different time frames.
So I guess I should hear from Vicky and her assessment first.
Your Honor, I think the court hit the nail on the head that those time restrictions can be, those times that this defendant is going to be working can be announced to the other unit. They can be notified of it, but they are aware of those times. People certainly do not want him to lose his job and his work and his ability to work. However, we still also concerned about the community and the witnesses who themselves were shot at, and in which the defendant is facing charges. And so we are asking the court to keep the tether in place, and so that the defendant work with the tether unit and give them those times when he will be at work and verify those his work hours and employment itself.
Jack, do you have some gunshot wounds?
Yes.
Okay, did you take care of, have you been to the doctor or been to see treatment for that yet?
I haven't been to an actual doctor's appointment. My aunt's a nurse, so she been, checking in and making sure that it's healing right. And everything. My parents, they don't have time to take me to my appointments because they're working, trying to make sure I can pay for my tether and the bills that I have since I get it.
So I'm going to allow you to employ yourself and have some flexibility to move out to make some money. I was looking for your condition, so I just have your scheduled doctor's appointment for wound treatment only. So I will change that. Your curfew, this is what I'm gonna do. Because you have DJing and maybe at nighttime, anything that's outside of 10 p.m. to 6 a.m. I will put on the order to let the tether unit know that you are allowed to go through during that time as long as you contact and let them know you have a job. Does that make sense?
Yeah, so basically I won't be able to do anything else during the day within the DJ services. Like I do.
No, 6 a.m. to 10 p.m. I'm not even putting a restriction, other than you can go out to work. You can go out to work, you can't have any contact with complaining witnesses, but between 10 p.m. and 6 a.m., you are to be at home curfew-wise, unless you provide to the tether unit a job that you have that may be outside at 10 p.m. to 6 a.m. You understand that? Does that make sense? Okay. Anything else?
No.
No.
Okay. All right, so we are set for March 2nd at 1:30, and I will make the adjustment on Mr. Jackson's tether.
Thank you, Judge.
Well,
Your Honor, I was appointed to represent a witness. Oh, sorry.
All right, so we got an example of this.
and then we have to address the witness issue. Attorney DeMaggio, that's next after,
Yep.
the court was.
I'll look into it. I know what you're saying.
Mr. Jackson has a $1 million personal bond.
I think, yeah, I mean, it was just changed to a personal bond,
The number is,
and then.
yeah, take that.
My notes say it was maybe reduced to 75 or 750,000 personal.
Yep, okay, all right. Okay, do we don't, okay, and those are my, and to continue the discussion about the two witnesses, I heard Aviator Session's position. So what did you have to say on that?
Your Honor, I think the issue may be moved at this point because an order was signed and they were both appointed counsel. They consulted with counsel already, but my position is that they approached me saying that they wanted to talk to a lawyer. I told them I could not be the one to talk to them about anything. So I don't have all the details of their concerns. And I would just know also that.
Wait, so you only said they need attorneys because they said we should talk to one?
They said that they had some concerns about testifying, right? And that they wanted to talk to a lawyer. And I understand the prosecution's position here, but they can't control what I'm gonna ask them when they take the witness stand to know whether or not they could be facing criminal charges, the prosecution. So her argument was that she's not gonna be asking any questions that could be incriminating, but she can't control what I'm gonna ask.
Okay, the only issue was whether or not, for me, whether witnesses are appointed.
Yes.
Counsel, because I don't know what their concerns are. If I testify, I might want to consult an attorney too.
Right.
So I will allow them to have counsel.
Sure.
And their attorneys could very well tell them,
Exactly.
yes, you need to continue to testify, or if there's some type of issue, we can just deal with it there.
I understand.
Okay.
I understand the preventative nature of that.
Anything else? Get on the record on this case.
Yeah.
All right. Sorry for the wait. Today was has been crazy. Tomorrow, I'm sending it.
I actually have an interview.
Still, okay, I mean, that's good news.
Okay, yeah.
That makes me feel even better.
Yeah.
Because it's not too late. No, yeah, they still take them throughout the whole process.
Are we on the record?
Yeah.
Briefly back on the record on people, State of Michigan versus Deontay Jackson, as well as Jordan Davidson. Before I get appearances, the defendants are not present. This is to discuss the issues regarding certain witnesses that they be testifying and attorneys who have been appointed to those witnesses. This is case 2261042. With that, appearance.
Lauren Sasser on behalf of the people, P 67104, neighborhood offender service by Natalie Phelps, P 83355 on behalf of Mr. Deontay Jackson.
Andrew DiMaggio, P 45619, on behalf of India Jordan.
Joseph Dillard, P 37225, on behalf of witness Chanel Lewis.
Okay, Attorney Dillard, do you want to place something on the record?
Your Honor, it's my understanding that this matter, I've been here, and it's my understanding that the court is going to continue this matter to March 2 at 1:30.
That's correct.
Okay. I've had an opportunity to speak with my client, however, that could be developed on March 2nd. Okay. Thank you, Your Honor.
Thank you. And Attorney DiMaggio, you said you have a conflict on.
Yeah, I cannot make it on the second. I have a prior engagement, legal engagement. So I did have an opportunity to speak to India Jordan extensively, but unfortunately will not be able to be here on the date.
Okay.
So I'll assign counsel, so I'll assign someone else.
Okay.
All right, thank you.
Thank you. We're on the record, this is USA University Dean Perry Ware, 2355326. Mr. Ware is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, felony, firearm. This is habitual offender report has been noticed today's date set for a preliminary examination. Appearances.
Good morning, Your Honor, Dr. K, 5931 for the people.
Good afternoon, Neighborhood Defender Service by Kate Grady, 83667, on behalf of Mr. Dean Ware, who appears with us in the courtroom. Mr. Ware, will you please state your name?
Dean Perry Ware Jr.
Good afternoon, and sorry for the delay today, it's been a rough day. To my understanding, Attorney Demott, your client is going to waive the exam?
That's incorrect, Your Honor.
Incorrect. Oh, it's a
Oh,
hold.
it's a hold.
Oh, okay, I don't know why I thought.
And we have some, the outstanding discovery issues, that the court will remember we were here on the 13th, due to, you're correct, on Valentine's Day.
Your Honor, before you proceed, could I just go to the officer in charge for the, to make sure there's any, courtroom for the discovery issues?
Oh, I know what it was, I thought this was.
Oh.
Oh, no, sorry, you gotta be a little excited. Okay, back on the record, Attorney Demott, as you.
Thank you. So, Your Honor, when we appeared on the 14th, we raised the issue that we were missing the body cam of the recovery of the weapon. That is, allegedly an issue in this case, and we're also missing the interrogation of my client. The people indicated that they were going to do a review to see if they could produce that. There was a different officer in charge in the hallway who did speak with me and said he located a video. I'm not sure who this officer in charge was present. So to date, I did send a follow-up email yesterday to the prosecutor, including Mr. Decker, indicating I still hadn't received anything, asking for an update. I was told that Mr. Decker was reaching out to the OIC. To date, I have not received any additional discovery nor heard an answer as to what's going on with the discovery.
Your Honor, the officer in charge, that's something to say about these two videos that are outstanding.
I'm the Center for Sergeant of Church Police Department. As far as the video,
I'm sorry, what's your name?
Nasenga Moore is my name.
And you're one of the officers on scene during this incident, correct?
Yes, ma'am.
Okay, you said sergeant?
Yes, ma'am.
Okay, what did you have to provide, what information?
That the videos, the body cameras were provided to the prosecution.
The ones, okay, I'm not sure if everyone is speaking of the same video.
Yes, so I have received 14 videos. I have reviewed over 20 hours of footage. I have not been able to identify, I have not been able to locate the recovery of the gun. And when my client's interrogation begins, it looks as though Officer Mahone reaches up and turns off his body cam. If there's an interrogation video out there, obviously I want that. So hearing that they've turned things over doesn't really help us. The other officer in charge in the hallway did say he located the interrogation, perhaps, and I asked him for a timestamp, he did not provide that. So if the people would like to provide the actual timestamps of where they're saying these portions are, I'm happy to look through the videos. But again, I have watched every single video.
Okay. So Sergeant Moore, is there a video of the interrogation?
I do not know, ma'am, but I'm not sure who she's speaking to. That's you refer to as the OIC.
The man who's out there, he came as the OIC last time, we can go ask his name, but in a black shirt.
And I believe he's just left, so.
That makes sense.
What's his name?
I believe you're referring to Leo Rose that works at PPU. That's who you're referring to. Oh, I thought he said black shirt. Maybe Leo Rose. He doesn't work on my crew, but he does work for my bodies.
Okay, well, he appeared last time we were here as the OIC. I followed up with him in the hallway afterwards. He did approach me about this case earlier and indicate a timestamp. I asked him to provide them. He did not. I'm hearing he has now left the building, which is a little bit baffling to me.
Okay. We have officer checking in the hallway to make sure he left before we move on.
Your Honor, Corporal Rhodes is to my left. He will address specifically the issue with the interrogation video. And he has also understands, know the existence or non-existence of the body worn camera we're talking about?
Yes.
Okay.
Corporal Rhodes, good afternoon.
Thank you, Dr. Officer Mahomes' video is there, but at a certain portion, he turns his video off. A lot of times when we're interrogating people, they will request that the questions we're asking, they won't be on camera. We may have been asking questions about someone else. That's why the rest of it is going. But I watched the video and I observed that Officer Mahone on this video, 32 minutes, gave him the constitutional rights for it. And that's where it stopped at. That's what it was. I just see it.
Okay, what was the second piece of?
Your Honor, just if I may, there are 3 videos. Corporal Mahone's video was turned off and on at multiple times throughout this multi-hour search warrant execution. I have received approximately 2 15-minute chunks that are separate files with separate names, and then a longer chunk. So when we have Sergeant Rhodes indicating that it's on a video at 32 seconds, I would ask that the people indicate the file name because, yeah, it's not being clear. There's not just one Officer Rhodes video.
Officer Mahone.
I apologize, Officer Mahone.
Okay, so are you saying 3 different videos or 3 different segments of the same video?
I have 3 different videos that it's like the beginning of the execution of search warrant breaking down a door. And then I have another 15-minute chunk that, again, they're not labeled, there's no timestamp, right? So I can't piece them together sequentially other than by guessing by the time of day, it gets dark throughout the video. But what I'm saying is there are 3 separate videos. So when we're hearing that he's identified this on a video, there are 3 separate videos for this officer.
Okay.
And all the files have different names.
Your Honor, it sounds to me like if it's, I'm sorry, you have a question for the officer?
No, Corporal Rhodes has it.
Okay, yes.
One of the videos is longer, I think it's like 43 minutes. On that video, the video showed where he given the defendant his constitutional rights, and that's at 32 minutes in that video.
Okay.
Then there's another video, we do have multiple videos. Mahomes' video was the other issue she was talking about was him recovering the gun.
Okay.
His camera doesn't show him recovering the gun, but another officer directs him to the gun and he recovers the gun. And that's it. And I watched that video when it was at Officer Lindsay. It was at 26 minutes and 32 seconds. I was just trying to be directly where she wanted to see. He directed them, told them that the gun was there and it wouldn't even recover.
So I received 4 separate videos for Lindsay. People can indicate which of these 4 videos. I have watched them all. I did not see anybody recovering the gun or anybody directing, but there's 4 separate videos for Officer.
I don't remember exactly which one it is, but I can review it. They want me to review it, put it out. It's just when we upload the video, we just upload all the videos and send it to the evidence.com. So
There's no sequential order.
no sequential.
All right. So, Attorney Demott, I can understand why you do not want to move forward until you see a
series of videos that existed. I don't think the police or prosecutor are trying to withhold information, I just think that it's too cute and it's all bunched up.
Understood, Judge, but I guess I would just say, we were here on the 14th, and I emailed yesterday a reminder because I hadn't heard anything, and just, I have spent, again, I've watched over 20 hours of footage multiple times on this case, and I don't see it, and I raised that to the court, and I raised that to the people, and to just come back and say, well, it's on there somewhere in the 20 hours of footage, frankly, is quite frustrating. And I think it's a failure to comply with the court's order to provide those videos.
Your Honor, we can't really send videos if we don't have them. If they don't exist, then there's nothing that, if we've given over and the officer in charge, Burrows has told me that everything that we have is turned over to the fence. If there's something, we can't create something out of nothing. So it seems to the people at this point that we could move forward with today's preliminary exam because we have, as the court has ordered us, turned over everything that we have.
The issue is not they're withholding, I believe they have set up what they have, as Mr. Decker said. Do you need time to discuss with the OIC while we're here, which Lindsay video they're referring to?
Yes, Your Honor, please. I would like to know what.
Okay. Before, I don't want to just adjourn this and we come back and same issue again.
Yeah, no, I am ready to go.
I assume that we're gonna go
Off the record?
I mean,
Okay, now we are back on the record on Dean Ware. Appearances?
Good afternoon, Your Honor. Eric Decker, PA 5931 for the people.
And good afternoon, Neighborhood Defender Service by Kate DeMont Grady, P 83667, on behalf of Mr. Dean Ware, who's present with us in the courtroom. Mr. Ware, please state your name.
Dean Ware Jr.
Good afternoon again. Okay. Attorney DeMont, I call you saying, I keep this.
Okay, 2 last names is hard.
I know, DeMont Grady. Did you have an opportunity to identify anything?
Your Honor, we went into the hallway and APA Decker did access the files on his computer. It became apparent that there's an Officer Richards whose body cam I have never been provided. The people are maintaining they have sent a link. I am showing everything that downloaded in my folder when we downloaded it. So I know they sent a link. I don't have it though. So I'm actually concerned that there might even be other videos that I'm missing. So yes, in some ways they were able to identify the recovery of the gun on Officer Richards whose body cam I do not have.
Your Honor, if you want to see the log, the way it works is that we assign all these videos under a certain case number, okay? And then we upload everything under the case number. Now, the video that was in that, that we were talking about that she has not seen, it was sent over to them. It was downloaded by Kristen Key on, on February 3rd. And it was also sent to Ms. DeMont Grady, on February 7th. And then it was downloaded on February 8th, twice by her, and then again by Kristen Key on February 8th. So what we're saying is that the videos were sent over to the defense. Now, if whatever happens after that, that sounds like an IT issue, and it sounds like maybe there's something else going on there, but I can say that the people have met our burden simply by making sure that they were provided.
Including the Richard video?
Yes, yeah.
Attorney DeMont Grady, with what you have seen, are you still uncomfortable with holding the exam?
Your Honor, I don't think I can meet my ethical obligations. This is the second time we've come. I know the court was running behind today. Mr. Ware, I don't want to adjourn this case. I really want to do this today, but I'm concerned, right? And I understand that people are saying they sent me a link. We've downloaded it. I've double checked all of the files. And I do not have that file. So whether they're saying it's an IT issue on my end, perhaps it's a evidence.com issue and technology, the platform that they use. I don't know where the breakdown is happening. Obviously, if I had it, I would be able to go forward. But at this point, I can't go forward without having all of the discovery.
This is an IT issue. This is not, I don't know what happened between the two of you communicating. I don't want to yarn it. I want to hold this exam today. So what needs to happen? Here's the exam.
I guess I would ask for just Officer Richard's body cam to be sent to me or time with the prosecutor's computer so I can, with volume on, they just showed me a very brief clip without volume, at least watch the recovery of the gun. And I would also just like to double check actually that I have all the other videos that are listed in the prosecutor's file. Okay. So that's what I would need, and if I, we could just pop into one of the little rooms out there and do that.
Okay. Maybe that can be done. Okay.
No, I didn't even check, I wasn't on
Uh-huh,
the run.
okay. I just wanna make sure, that's all.
Let me double check. Thank you so much. I got here at 7:30 to look for it. I was like, I'm just gonna ask you.
Yeah.
That's like 6:09. Maybe because. Yet, but I'm going to check before you leave to make sure I get it.
Okay.
Yeah, the last one we got was at 10:28. Sometimes. So hopefully.
We're back on the record on Mr. D. Perry Ware, case number 2355336, appearances.
Well, Your Honor, that's, Eric Decker, PA 5931 for the people.
Good afternoon, Neighborhood Defender Service, Kate Demott Grady, 83667, on behalf of Mr. Dean Ware, who's with us in the courtroom. Mr. Ware, please state your name.
Dean Perry Ware Jr.
Okay, and Attorney Demott Grady, have you had an opportunity to review the discovery of the videos that you mentioned earlier?
Your Honor, yes, I reviewed a portion of Officer Richard's body cam and I'm able to see, it's not the actual recovery of the gun, but the indication of the gun in the body.
Are we ready to proceed now?
Yes, Your Honor.
Any preliminary matters?
Your Honor, this time the people move to admit pursuant to MCL 76611B1B, a certified copy of the defendant's previous felony charges for weapons felony firearm from 2011. Certified copy. Did I not say certified copy?
I'm just asking.
Certified copy, yes.
Okay, that's how it's changed.
I see now, acknowledging yes, certified.
Okay, we'll be with it.
Thank you.
Yeah.
Your Honor, I would ask for a mutual order of sequestration.
Okay.
People requested an exception for the officer in charge.
Any objection?
Defense just asked, is this officer in charge expected to testify?
No, no.
Okay, then no objection.
All right, so, and anyone, there's no one in here, actually, except for the defendant, the officer in charge, and the attorneys as well as staff. If there's anyone watching on YouTube Live who may be a witness to this case, it's now time for you to all. With that, anything else?
No, Your Honor.
Okay, sounds good.
People call police officer Lindsay.
Whenever you're ready, Mr.
Please state your name for the record.
Officer Lindsay,
Okay.
Detroit Police Department, Dash 32.
Okay, are you currently employed?
Yes, sir.
Where are you currently employed?
City of Detroit, Detroit Police Department.
How long have you been there?
Almost 6 years.
6 years. Does this mean that you were working in that capacity on January 26, 2023 of this year?
Correct.
Okay, did your duties as a police officer take you to 13303 Greener Street in the city of Detroit, and County of Wayne?
Yes.
Does that address sound familiar to you?
Yes.
Let me go back for a second. So when you, your duties as a police officer, what does that entail?
Currently now I'm assigned to the narcotics division.
Okay. So what kind of work does that do?
We execute narcotic search warrants and deal with narcotics throughout the city of Detroit.
Okay. So let's go back to when I said the 13303 Greener Street. Does that sound like a familiar address to you?
Yes.
I already asked that question. Why does that sound familiar?
Because we executed a narcotic search warrant at that location.
Okay. So did you, were you the affiant on that?
Yes.
Okay. So you got the search warrant. So when you arrived at the property, what happened?
So we arrived at the property, we approached the property.
Objection as to we lacks foundation.
Okay, you just, if you're stating other people were with you, state for their position.
I can ask that question.
Okay.
So when you, on that day, were you alone or with a partner?
I was with my crew.
With your crew?
Yes, multiple people.
How many people are in your crew?
A total of 6.
Okay.
And then we had 2 additional personnel.
Okay, do you remember who you were with that day?
Yes, I do.
All right, could you state their names, please?
Yes, Sergeant Moore, Corporal Mahone, Officer Page, Officer Richards, Officer Robson, Officer Kelsey, and Officer Nelson.
Okay. So when you arrived at the property that we discussed earlier, what happened?
So we carried out the search warrant at that location. Upon approach, my sergeant ordered forced entry inside the location.
Objection, hearsay.
The statement is being offered not for the effect of the mind of the listener, and not for the truth of the matter, sir.
Okay. So entry was made inside the location. I detained Mr. Ware, who's sitting back there with a black jacket or a hoodie on, inside the location, inside of the dining room area.
Okay. Real quickly again, so is there somebody in this courtroom that you recognize today?
Yes, sir.
Okay, and could you maybe point something out, point them out, tell me something they're wearing?
He has on a black jacket, red hoodie underneath.
Okay. Let the record reflect that the officer has identified the defendant, who is Dean Ware. Okay, so when, like, what, so you said what happened initially. So when you arrived at the location and then you saw the person you identified as the defendant, then what happened?
At that point, once he was detained, the location was searched for contraband and narcotics.
Objection again, lacks foundation. The residence was searched. What did this officer specifically do? The whole point of this is for them to tell the court exactly what the officer did, so I can cross-examine people. When we just have things happened, it's not. I don't believe it's proper.
Well, when he says that he's the next thing, the next step in the process is that he is going to then go search for things, then we probably would then narrow it down after that, because he's basically just telling us what the second step is.
The question was what happened next, right?
Yeah.
And he said that he saw the defendant be detained.
I'm sorry, I heard him say that the house was searched. Who searched the house is my question.
That could be the next question. Or on cross.
I guess I'm just saying, when officers are testifying, when there's 7 people doing things, generally making I statements of what you did is what is the narrative that this officer can speak to his personal experience. There's multiple rooms in this house. He's not in every room. So
You can speak with observations as well.
obviously, yes, but there's a whole house and there's 7 people searching. I'm just asking for clarity, foundation of you're in this room, what's happening, steps like that.
I don't even think they've gotten there yet. You just think his house was searched, so.
Right, and
If
who
you don't
searched the
want to
house?
say that he was told or something that he wasn't observing or doing himself. And it may be because I don't know what's going on. You have the discovery and you know.
Correct.
But for me, he hasn't said anything yet, other than the house was searched.
So he searched the house? The house was searched is a conclusory statement. Who searched the house?
Okay, you clarifying as will be part of the search.
Okay, thank you, Your Honor. After he was detained, what did you do?
So after he was detained, I did assist in searching. I searched the bathroom of the residence. Upon searching the bathroom of the residence.
If I may, so you said you were assisted searching. Who were you alone or with a partner?
At the moment, I was alone.
Okay, so when you started doing that, what happened?
I conducted a search in the bathroom and I discovered a firearm inside of a broom closet.
Okay.
Or
So
a closet per se.
when you say a firearm, could you be more specific?
It was a handgun, semi-automatic, black in color.
Okay. So when you found that, what did you do?
I alerted Officer Richards of my findings.
Okay. So then after you informed him, what did you do?
I informed him and he came by and him and Officer Mahomes, Corporal Mahomes, sorry. Corporal Mahomes comes to me.
Okay. So then was that it? Is that all you found in the?
No, later on, I also searched the living room area.
Okay.
I found a set of keys that the defendant claimed ownership to. He was able to identify which key operated which door.
Okay.
One key operated the front door, one key operated the back door.
Narrative?
Okay. So after you found the keys, what'd you do?
I proceeded to the door to make sure that the keys actually operated the door.
Okay. Which door?
One for the front and also one for the back.
Okay. So then after you did that, what did you do?
From there, the keys were placed on evidence, and that was pretty much all I did there.
Okay, so then after that, what did you do? If anything?
Yeah, that's it.
Okay, nothing further.
Just very briefly, Officer Lindsay, you've been a police officer for 6 years, correct?
Approaching 6 years.
And you've no doubt had a lot of training over those 6 years.
Pardon me, I couldn't hear.
You've had a lot of training during those 6 years.
I would say a fair amount.
And part of that training is to write police reports, correct?
Correct.
And you, in a police report, would include all the relevant details, correct?
Correct.
And you write those reports in close proximity, like right after the event happens, generally, correct?
Not necessarily, ma'am.
Okay, in this instance, did you write your report that same evening?
Yes.
And you would agree that the details of that incident were fresh in your mind that evening?
Yes.
And you would agree, nowhere in your report did you write that you located a gun in the bathroom?
No, ma'am.
And regarding the keys, you took 2 keys off of that key ring, correct?
Correct.
And Mr. Ware asked you, said, I need those keys back, it has my house key on it, correct?
Correct.
And that house key, he wasn't referring to the house that he was in, correct?
Not to my knowledge, ma'am.
Nothing further.
Nothing further, Your Honor.
Lindsay, any other witnesses?
I'm thinking about it, Your Honor. I'm sorry.
Yeah, the people called Corporal Mahone.
After you give her your name also.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Have a seat. Make sure you speak up.
All set?
Whenever you're ready.
Okay, please restate your name for the record.
Derek Mahone.
Are you currently employed?
Yes.
Where are you currently employed?
City Detroit Police Department.
Okay. What kind of work do you do there?
Work for the narcotics unit.
Okay. How long have you been there?
In the narcotics almost 6 years.
Okay. So have you so were you working on that capacity on January 26th of 2023 this year?
Yes.
Okay. What kind of stuff, what kind of things do you do for the, as for the narcotics department?
A lot of surveillance, street enforcement operations, and execute narcotic search warrants.
Did your duties as a police officer take you to 13303 Grenier Street in the city of Detroit and County of Wayne?
That's correct.
And that was on that day of January 26th?
That's correct.
Okay, so why does that address sound familiar to you?
No, we executed a narcotic search warrant.
Okay, so, when you say we, were you alone or with a partner?
My team.
You with your team?
Yes.
Could you state who was on your team?
Officers.
Yes, please.
Officer Lindsay, Officer Richardson, Officer Page, Officer Roberson, Sergeant Moore. I believe those are everybody was.
Okay, so, when you arrived at the property, what'd you do?
We arrived at the property, we presented, we announced our purpose for being there, and no answer came from inside the location, and forced entry was made to the front door.
Okay, so after you made forced entry, then after that, what happened?
After forced entry was made, we began searching and detaining the defendant. I believe he was
came and laid down on the ground. And we began searching in the area safe.
Okay. Now, is the person you described as a defendant, are they in the courtroom today?
Yes,
Okay, could you point them out and tell me something they're wearing, please?
the red hoodie and the black jacket.
Okay. Let the record reflect, Your Honor, that the officer has identified the defendant, Dean Ware. Okay, so after you saw him, then what did you do?
I didn't do anything. I believe one of my teammates placed him in handcuffs.
Okay, so then after that, what happened?
After that, we began searching the location for narcotics, contraband, and weapons. So we recovered
Okay.
a handgun.
Well, what did you recover anything personally?
Yes.
What did you recover?
It's gonna be a handgun.
Okay, could you describe the handgun, please?
It's a black 9mm, I believe, something of that nature.
Okay. Okay, so when you found the handgun, what did you do?
I found the handgun, I made the handgun safe, and I logged it in, and I placed it on evidence.
Okay, was there any ammunition in it?
Can't recall.
Okay. All right, so after you placed it on evidence, what if anything happened after that?
After it's placed on evidence, everything else, and we have everything logged in, and then after that, I did interrogation on the defendant.
Okay. So what happened after that?
We did interrogation, we were talking about things due to narcotics.
Okay.
Different individuals that come in our house, things of that nature.
Objection as to voluntariness of the statement. He's discussing the interrogation with my client.
He didn't say anything specific. He just was saying that he conducted an interrogation.
Talking about that. Yeah. Which is not an issue in this case, but I would just say that they're saying they conducted an interrogation and people's burden to establish that that was conducted in accordance with Miranda. Okay.
Okay.
What's the objection then? I don't understand it. He didn't, so we know he works for narcotics. There's no search warrant, execute search warrant for narcotics. He was beginning to, in my opinion, he was beginning to discuss the contents of the interrogation.
Okay.
How is it even relevant?
It's not. We're gonna be. I think that there were nothing further.
Okay.
All right. Thank you.
Good afternoon, Sergeant Mahone.
Good afternoon.
I'm gonna ask you some questions. If you don't understand the question, just let me know and I'll rephrase. Is that fair?
Yes.
So. You've been an officer for how many years?
23 years.
23. And no doubt you received training during that time.
Yes.
And you've been trained on how to execute search warrants.
Yes.
And you stated on direct that you and your crew went up onto the porch.
Yes.
And you had the ramp, correct?
That's correct.
And that you announced,
Yes.
and then after no answer, made forced entry.
That's correct.
How much time elapsed between when you announced and when you made forced entry? Can you estimate?
We get a reasonable time for someone to come get the front door. I can't remember, could have been a minute or maybe a little bit less.
And you were wearing a body cam that day, correct?
Repeat?
You were wearing a body cam that day, correct?
Yes.
And you
Yes.
recognize that footage, correct?
Yes.
Your Honor, may I approach? Sure. I'm showing you a still from your body cam. Do you recognize that?
Mm-hmm.
You recognize your name there, Derek Mahone.
That's correct.
So would it sound right to you that less than a second elapsed between when you announced and when you started to force entry?
I can't recall.
Would viewing this refresh your recollection?
Yes.
Starting the video at 1 minute and 27 seconds. you would agree that approximately 1 second elapsed between when the search warrant was shouted and you began being at the door.
Yes,
So we have 1 second between police search warrant and when you begin busting out the door.
if that's what the video shows. Yes.
So you enter into the residence.
Mhm.
Is that a yes?
Yes,
And Mr. Ware is lying on the floor in the dining room.
yes, I think so.
And at one point, when you filled out his interrogation form, you went over a Miranda rights form with him, correct?
That's correct.
And you put his address on there from his ID. You had his ID in your hand.
That's correct.
And that address you put down was on Garrett, correct?
Yes,
A different street than the house the search warrant was executed on.
that's correct.
And what street did you say? Garrett, Garrick. And that address specifically was 3348 Garrett.
I believe so.
And Mr. Ware indicated to you that it was his brother's house he was in on Grimer, correct?
I believe so. Yes.
And that he was, withdrawing that question 1 moment. In the search of the house that you were executing the search warrant, you didn't recover any mail with Mr. Ware's name, correct?
I don't remember. No.
That would have been logged into evidence, correct?
Yes,
And you didn't find any personal items of Mr. Ware, correct?
I didn't recover any personal items, no.
And you would agree that part of DPD policy is that interrogations should be recorded,
Yes,
and that's to protect DPD from claims of improper practice. Yes.
yes,
And you would agree that you, after filling out the Miranda form with Mr. Ware, you reached up and turned your body cam off, correct?
I can't exactly remember.
Would watching, reviewing your body camera footage refresh your recollection?
Yes, it would.
Your Honor, may I approach? Yes. Starting at 42 seconds, 42 minutes and 15 seconds. Did that refresh your recollection?
Yes, it does.
So you filled out the Miranda rights form,
Yes,
and then you reached up and turned your body cam off, correct?
yes, I did.
And when you recovered the firearm, did you have your body cam on you?
I believe so, yes.
And was that body camera on?
No, it wasn't. I was told that my body camera was not operable at the time I picked up the weapon.
And have you turned your body camera off?
I went outside, got on the phone, possibly, yes.
Nothing further.
Nothing further. No, Your Honor.
No, Your Honor, I apologize. Okay, whenever you're ready.
Thank you, Your Honor. The people motion for bind over to circuit court. A question of fact has been established by the testimony today, and we reserve time for.
Yes, Your Honor, defense objects to the bind over. I guess I would start with mere presence in a house does not make you responsible for everything that's found in that house, correct? So here we have Mr. Ware in a house that is not his address. We have no mail that's recovered. We have no personal items of his that are recovered. Yes, they had to recover a key to that house from his keychain. I have multiple people's keys, family members and friends on my key ring right now. That does not mean I am responsible for everything in their house. So in terms of the actual connection, there needs to be a nexus. Yes, we're at a probable cause stage, but probable cause, there is still a standard that must be met, and probable cause is more than a hunch. Additionally, Judge, the officers clearly, as the court heard Officer Mahone testify, 1 second maximum elapsed between when they announced and when they entered. They clearly violated the knock and announce statute. I understand that the exclusionary rule is not the remedy, but I think that in terms of the officer's credibility, it's something for the court to take into account. First, we heard on direct that Officer Mahone said maybe they waited a minute, they announced their presence, they waited for somebody to answer. You heard Officer Mahone say they're required to wait a reasonable amount of time for somebody to answer. And then if we look at their body cam, it's less than a second before they start breaking down that door. And I think that that goes to their overall credibility and trustworthiness. I also think, that we've heard no testimony of anything found on Mr. Ware connecting him to that weapon. So if a holster had been found on him, or if ammunition or something connecting him to that weapon, I would acknowledge that this would be a question of fact for a trier of fact. But what we have here is a person, Mr. Ware is at his brother's house, and a search is done and a gun is found, and the one person in that house, they say, we're charging you. That's not enough. Probable cause requires more, and I would move to dismiss this case.
Your Honor, the question of fact, has been established by the testimony that we heard today. As far as the defense's argument about the knock and announce and whether that goes to credibility, if our argument is for credibility, that credibility is something to be determined by the trier of fact. When it comes to that particular question, it seems like if there's any kind of a credibility question, that's something that a jury should be able to observe and make their own determinations on. As far as the mere presence in the house, it's not mere presence. And we did hear testimony that the defendant was in the back room, and then the back room is where the
objection. Those are facts not in evidence.
Also, but there, you spoke to, on both sides, actually, since that objection's been made, the defendant's brother's house. That was never in testimony.
I did ask Sergeant Mahone, I said when you were doing it, the interrogation, that he had a different address on his ID and that he had indicated he was at his brother's house, and he said yes.
Oh, okay, I'm sorry. So
Yes.
back to your objection.
And yeah, with police officer Lindsay, he said that he saw that the defendant was coming out of the back room.
I did not hear that in the testimony.
What I heard was that when the door was open, he was on the floor.
Okay.
And that they went to the bathroom, or that Officer Lindsay went into the bathroom, and that's where he recovered the gun along with Officer Really.
Okay, I misheard the testimony.
That's right.
Okay, so what we do have is that we do have the defendant in the house. We do have, as part of what was recovered, the keys to not only the front door, but also the back door. And we have an admission by the defendant saying specifically that those are keys that he takes possession of. That is something that we also heard as far as testimony from the officer. It seems as though that establishes enough of the nexus that there would be possession, and this is something that has met the probable cause standard, is now available to be seen by the trier of fact. we keep a motion for bind over to the Third Circuit Court. Thank you.
Okay, then council brought up two very, important categories or issues here. One being the connection to the gun. As I recall testimony, Mr. Ware was not in a bedroom, or in a room, he was in the main area, with his, down on the floor, once the police came into the house. He was not in the bedroom. Based on testimony, there was no identification as to whether he was sleeping there, what type of ownership he was taking in that house. There were keys in his possession that opened the front and back door. However, there was no mail or anything indicating that that was his residence. And also there was ID on his person for testimony from one of the officers that had a different address. The second issue is credibility, which can be addressed at the preliminary exam. The testimony about whether or not the video, whether or not the knock and announce was within a reasonable amount of time. I'm not going to get into the knock and announce issue, but the testimony versus the video was completely contradictory. As well as the video, the body cam being turned off or mistakenly turned off or don't remember it being turned off. My main issue is that there's no connection, a strong enough connection, even at this standard, to show that the defendant resided there based off of the testimony. There's nothing that attaches him there other than he was physically in the place, which could have been anyone's home. And also the gun was in a common area place, the bathroom. It was not like he was sitting on the couch and the gun was within reach. So with that, I am going to dismiss for insufficient evidence on all counts. I tried to catch you. I knew you were gonna say, look, let me just say that today.